Good morning, good morning, good morning, Law Nerd. It is Thursday, it's March 20th. Today we are back in live court for the Commonwealth versus Karen Reed. There are supposed to be pretrial motions today and a final pretrial conference, but there's also a motion to dismiss pending, and there is also that motion to continue pending. I think the motion to continue is something that might get taken up today. Plus, there was a hearing on a related matter that is not technically the Karen Reed case, but is related to the Karen Reed case. Because remember, the Commonwealth is trying to get the phone records of Turtle Boy, who is being prosecuted in separate cases. The Commonwealth is arguing that those phone records will show or may show that there was conversation between Aidan Kearney and Karen Reed that go to her state of mind, not that go to a criminal witness intimidation, but that go to her consciousness of guilt. That was argued briefly this morning before the hearing that we are going live to now is. But if we have time at the end of this hearing, we will go back and watch that hearing from this morning where the Commonwealth is trying to get those phone records. No decision was made. That's under submission. All could change today if the court decides to continue this case. This should be a final pretrial conference, but we really don't know because we haven't seen what happens yet today, and we don't know if the court's continuing the case with that pending appeal. So again, like I said on stream yesterday, the Commonwealth mentioned in that hearing multiple times what Karen Reed said in the Discovery ID Plus 5-part docuseries about providing information to and having conversations with Aidan Kearney. So Kearney, I'm going to continue to pronounce it two ways. I apologize, but they are continuing to bring up what she has said on TV, and offered to provide the court a clip of that this morning and put it in their moving papers. So we are going to continue to see the Commonwealth leveraging things that Karen Reed said. And when I went through and watched the series, Karen Reed does say, my attorney said, yes, we can give him public information. That is what she said. The Commonwealth today said that there was evidence in the grand jury that non-public information was given. That is something that was not said by Karen Reed. But she said her attorneys told her to do it through an intermediary, through a third party, to give him information. And then she started having questions about the third party. This is what she said in the docuseries, and then started conversing with him herself. And then they were talking every single day. So yes, the Commonwealth is going to leverage that to try to get these phone records. We will talk about that more at the end of today's hearing, because now we are going to live court in just a moment for this pretrial hearing. So we need to roll the intro. Law Nerds, let me know where you're coming in from, what you're drinking. I've got coffee. I've got iced coffee. We need iced coffee. Lyndon in the chat said that's a whole separate thread of this web. It is, because the motion with regard to the phone records is taking part in a different case number, because it is completely housed in a separate case with a separate special prosecutor and the rest of it. But the Commonwealth wants to use it in this case, much like the defense is asking for records from the Birchmore case. And the Commonwealth objected to that. Emily, how are they different? Same to me. Same. If we're going to use them with regard to witnesses, the way the Commonwealth is going after them is a little bit different, because they're talking about consciousness of guilt. It doesn't go maybe to a specific witness, but same. But same. So we saw a separate judge hearing that motion today earlier. We'll get to that later. Hopefully we'll have time. We'll see how long court goes today. Let's roll the intro, and then we are going to thank our stream sponsor, because our stream sponsors, well, A, provide us stuff that we love, and B, let me do things like clip TV shows that might get salty about it, because we've got sponsors and we've got law nerds. So we do what we want. Let's roll. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. And yes, as I said, we do have a stream sponsor today. We are powered by Law Nerds, and our Law Nerds love this sponsor because I know what you're doing when watching stream, Law Nerds, and it is okay. I 100% agree, because even though your eyes and ears are busy, your hands are not. So whether you are making cupcakes, crocheting, editing content, drawing, doing schoolwork, doing work, or playing one of my favorite mobile games, Midas Merge, if you are not onto Midas Merge yet, listen up, because there is a gift for the first of you to use our link, because we love us some Midas Merge, and Midas Merge loves you guys too. So thank you to today's stream sponsor, Midas Merge. Law Nerd, you know how much I love my mobile gaming, and Midas Merge is absolutely one of my favorites. Not only because the game is beautifully designed and fun to play, but the creatures are adorable. There's tons to merge and discover. Plus, the interaction with the Law Nerds in our friends community is so much fun. And in case you were wondering what to do as we get into trial season with lots of long court streams, today's sponsor, Midas Merge, has got you covered. In Midas Merge, you team up with King Midas and Queen Leah to revive the Gardens of Gold, which are under the shadow of Nyx, the goddess of night. I can't wait to learn more about Nyx. I love the mythology of Nyx, and I can't wait to see how it plays out in this game. One of the things that makes Midas Merge a really fun game to play is it's free to download, free to play, but you don't run into those annoying dead ends where you have to wait for something to reload or wait to have more power. There is always something going on. There is always more to do, and you can play it anytime, anywhere, because you don't need Wi-Fi. I love that Midas Merge is an ad-free experience with no dead ends. And Law Nerds, you know what's coming next. If you're the first 100 to install via my link or the QR code, you will receive a customized U-Turtle Level 2. This super cute creature boosts your garden and, of course, is personalized by me and named Pickle. You know why. So don't miss out. Be among the first 100 and download Midas Merge now. Thank you, Midas Merge, for sponsoring another stream. So no joke, when my mom was visiting before the neurovirus took over our entire household, except for me, so I got to take care of everyone, which was a delight. My mom's like, oh, I was watching this on the plane. I download this for the plane, blah, 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 blah. And she's like, what do you download for the plane? I'm like, nothing. She's like, what do you mean you don't download anything to watch on the plane? I'm like, I put on an audiobook and play Midas Merge. She's like, really? I'm like, yes, I do. Yes, I do. I put on an audiobook and play Midas Merge on the flight because you don't hit dead ends. I love it. So Law Nerds are asking about friend codes. I will put a post in our member spaces where you guys can share friend codes. If you want to share them in the chat publicly, you are always welcome to do that. It's your choice, but I will put it up in our members spaces as well. For now, we are going to court. So hear ye, because I think the hear ye's got cut off this morning and I feel like we've been denied them. Hear ye. The Superior Court of Norfolk is called to order. Draw near and ye shall be heard. Something like that. But, you know, as we're talking about my flights and no timeouts and no dead ends and no having to wait for things to refill and no Wi-Fi, we do need to go to Massachusetts. So let's go to court, shall we? Court is in session, Law Nerds. And I hope you're enjoying downloading and playing Midas Merge. We barely got it. We got the end of the hear ye's. Oh, the very end. No, that was just the remain seated. That's so disappointing. But we have closed captioning, and that's amazing.
Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for the Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Sorry, Ms. Jackson. We are
morning,
in
Mr.
court.
Alessi.
Good morning, Your Honor. David Unetti.
Again.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All
Good
right,
morning, Law Nerds.
So we have a lot to cover this morning.
Do we?
But what I want to start with...
The continuance.
I just handed a couple of things, too, that I'm going to need some time to read.
I want to start with the continuance. I do. Because I have questions. I have questions.
What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date.
Law Nerds. Law Nerds. It's so early for me to be like, I would like us to start with this, and then we do.
On or after April 25th.
Yep, we covered that yesterday on
We can
stream.
argue that. because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
Does not mean it's likely going to happen. Your Honor, can we roll the tape of you being like, I've got concerns. I've got concerns. She is going to make them sing for their supper. But I think it's possible. I really do. We covered this yesterday. But all right, Mr. Jackson, make use of the purple tie. Let's go.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just
Hopefully that's a little bit better.
said, but I can sort of clarify it
And
narrow
not
it
too
down.
loud.
If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal
This
or
is what I
something
talked
else,
about.
Additional hearings, etc., then that puts the entire case in jeopardy.
Sounds better.
Once
Thanks, chat.
The jury ultimately is
I rely on y'all.
impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where
Your
we
Honor,
will seek a mistrial.
This could be a shit show.
Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now
Is very different.
clearly is a murder case.
Very different.
Ultimately, along with
All three indictments, correct? You're
I understand
defending
that,
all 3.
But it starts with murder. That's the sun rises and falls on a murder charge.
Murder is
There's
the
also
case that
vehicular
they gave.
manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well.
This is a very different case if it's just count 2. It is a very different case if it's just count 2. And I don't think that can be overstated. It is a very different case.
Well, that's a very different jury and a very different trial strategy
it's
than simply
literally everything
count
different.
2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree.
I
That
agree.
probably is the better practice.
The law nerds agree. We agree.
asked
We're with
the
you.
court to extend the beginning of the trial to April 25th, which is
I don't want it to
about a
get continued,
3.5 week
but
continuance.
it makes sense.
And I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, it makes sense.
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse.
Then
The
just say
concern
yes.
is that this case
Oi.
in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which
The court's aware.
hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control.
The habeas petition was ruled on so quickly. There's not a chance that the federal judges are unaware of what's going on in this case. I don't know if anyone in Boston is unaware of this case. So I don't want it to get continued. It frustrates my schedule. I think it is the right thing to do. I think that it's difficult for the defense to ask for this request because it also gives the Commonwealth more time to do the shit that they're trying to do. Getting phone records, getting more uncut interview footage. It also gives the Commonwealth more time. Giving Brennan more time when he is the newest to this case might not be helpful, but the defense isn't wrong to ask for this. And the court's denied the defense's motion to continue before, and she's denied motions to continue where both sides have agreed. But I think this one is this makes sense. And it's a twofer because the judge is worried about publicity. Get a little bit further out from it.
Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark.
Thank you, Sarah. We
that
have
will
lots of
allow for a
Australian law
circuit
nerds. It's good to see you.
resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
So yes?
Okay. Well, I'm not going to grant the motion.
Oh.
All right. We have jurors coming in that were summoned months.
She can rule from the bench. She does rule from the bench. Wow. All right. Well, I'm not going to do that. Okay. Well, they're going to file a stay in federal court and we'll see what's going to happen. I guess the case isn't getting continued. We'll continue with pretrial motion. All right.
All right. We have jurors coming in.
All right. It took us months to get these jurors. Your Honor, the defendant's being tried for murder.
We can have this trial in April.
She's like, my schedule would be fucked. I'm not doing it.
Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
That's not the worst compromise.
All right, so let's go.
That's not the worst compromise. It is a compromise. That is not the worst compromise. Here's what the court said. I'm going to start impaneling the jury. We're not going to have to rush it. Impaneling the jury might take 2 weeks, might take 3 weeks. We already have summons them. It will take 10 weeks to get another veneer of jurors at a minimum. So they might bump up against the end of April with jury selection, and then she's not going to swear them in. Jeopardy doesn't attach until they're sworn. Because the defendant's out of custody, this is not a timing issue. So because she's not going to swear the jury, then jeopardy wouldn't attach. Miriam, great question. When does jeopardy attach exactly? Swearing the jury is when jeopardy would attach here. There are other scenarios where there are other arguments, but she's not going to swear the panel, so jeopardy won't attach. That is a compromise. That's a compromise. That's a compromise. So, okay, that is a practical solution. We will let you not start evidence until the end of April to give you some time. And we will take our time working through these jurors, and then we won't be rushed. I'm not mad about it. I'm not mad about it. I'm not mad at that ruling. That actually is essentially giving the defense what they have asked for, but also not wasting 10 weeks for the jury commissioner. That is judicial efficiency. It is possible. Now I'm going to get mad when it doesn't happen more.
Go to the next motion, and then we'll go back to doing them somewhat in order.
Back to pretrial motions.
Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? 'Cause
Oh,
I
this
don't know
motion.
Where I put it.
Now we're back to pretrial motions. Jury selection is starting April 1st. Jury selection might take 3 weeks. It looks like evidence might start April
We did hear
28th.
from people this morning. I know you all have. I have it. I have it, Jim.
Vanda
think
said,
Mr.
does that mean the
McDermott
jury
gave
can
you a
read up on the
copy
case
of-
before being sworn in? No.
I guess.
Nope.
What local merchants have requested.
There's a lot of questions here, so I'm going to answer them. Not swearing in the panel means jeopardy doesn't attach. The panel will be admonished. Do not read anything about this case. Look at anything about this case. They'll get all those admonishments, but they won't formally be sworn in. So jeopardy will not attach. That means if they bring back in, if they pick 18 and only 16 show back up, they can still pick more jurors or not. It is a very, very practical solution, but it will kind of freeze the proceeding for a couple days before starting opening statements. We will get to what jeopardy means later. It is part of the constitutional protection of when someone is actually put in jeopardy, meaning that if something goes wrong, there needs to be a mistrial. There are situations where you can retry a case and situations where you can't. We've talked so much about it with regard to the appeal, but that is what jeopardy means for a double jeopardy context. If the jury's not sworn in and the wheels fall off, you can start again. Does that help? Because we've gone through jeopardy quite a lot. Hopefully that helps. Let's keep going.
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Look, the movie Double Jeopardy is a great treatise in the concept of double jeopardy.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process.
We are now moving into the Commonwealth's motion for a buffer zone. The Commonwealth wants, and we haven't gone over this MIL yet, the Commonwealth wants a bigger buffer zone than the last trial. They want the ability for law enforcement to enforce the buffer zone. They want no shirts, no honking, no anything supporting one side or the other, no signs. This is a complicated thing because people have a First Amendment right, and the defendant and the Commonwealth have a right to a fair trial. That right's a little bit different depending on whether you're the defendant or the Commonwealth. But this is where the tensions of the court, the case, the jury, and the public start to butt up against each other. And we see these tensions in high-profile cases a lot. So let's continue on.
We are concerned, based on past reports and information, that noise, interruption,
I mean, you
and
can hear
other
the honking
uncontrollable events can
through the cameras.
potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but
Matt Bond, I would love
other
that. Thank
types of
you.
noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations.
Jay Wildberry,
to the
he
court
sounds
to
deflated day over day.
move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be.
There was a motion
sensitive to
filed
the
by
community's
business
concerns.
owners.
But importantly, that
This morning,
closeness
it
and
sounds
that
like.
amount of volume and influence in the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will
Remind me to tell
potentially,
you a story about a
some of
jury
the
I had
outside
complain about
impact
outside noise and
adverse
impact
influence on the jury.
and adverse influence.
All right, there's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right, with that, does the defense object to the buffer zone?
We take no position.
Okay.
The defense is like,
All right,
y'all sort
I'll
it.
take this under advisement. I have to figure out exactly how far this is, and I have not yet had a chance to read and consider
The business owners.
today's email from the merchants. Okay,
All right, that's under submission.
yes.
I had one jury, and they came back pretty fast, but I had one jury when I was working in Long Beach complain about noise because they were trying to deliberate during the Long Beach Grand Prix. And as you were in the court, the courtroom and the jury room, all you could hear were the cars from the Grand Prix going like, "Vroom, vroom." And the jurors were like, can we just go watch the Long Beach Grand Prix, like out on the balcony? Because it's really distracting to just hear the cars going. So the zooming was distracting to the jurors. We tried to avoid as best we can, or we did try to avoid as best we could, doing a trial during the Long Beach Grand Prix. But the Long Beach Grand Prix is wild. It's just like right there. So it was hilarious. And then the jurors were just like, can we just, everybody else is outside in the sun drinking and watching the cars go. Can we go do that? We don't want to be here. It was funny. It was one of the only times I've ever had jurors in that way complain about noise. I've had other experiences, but the noise was definitely one of them. Emma said, oh my God, I remember when they used to set the track up tight right near where the Ice Dogs play. Fun fact, second date with Dr. B was an Ice Dogs game, Emma. You've unlocked deep E and Dr. B lore talking about the Ice Dogs. We would go see the Ice Dogs play all the time. And then one of the Ice Dogs players ended up playing for the LA Kings, and then his kid ended up on the same baseball team as my kid. And we were like, holy shit, it's a small world. Let's get back to court. We'll talk lore stories later.
Can I just have this mark for identification for this hearing? Identification?
She's sighing at the clerk.
For the record, that came
The clerk's like, can we just identify that? And she's like, oh, for fuck's sake. Also last night, Dr. B and I were watching the last part of the docuseries. He hadn't seen any of it. And they were doing the part where she was reading that last jury note and then dismissing the jury. He's like, she seems so put out. And I was just like, that's a really interesting assessment. He's like, she seems so over it and so put out and so done. And that was her reading that last jury note and being like, I'm declaring a mistrial. I'm like, he's watched nothing about this case. He has seen not a minute of court. He has seen not an episode of the docuseries until last night. And he was like, okay.
hearing identification.
So it's not just the lawyers that she's
From the record, that came
put
from
out
the
by.
Dedham Square Circle, the organization that runs the Dedham Farmers Market.
So they're marking for the record the email.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways.
There is a lot of
right.
overlap. The final trial conference will probably be April 1st. Aussie Lawnerd, there are a lot of Aussie. It's like Aussie, oi, oi, oi this morning. Y'all are in the land down under tuning in for court. It's good to see you.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth.
Leonard's
We did
only
not
making me
file that
giggle.
publicly.
Okay.
We'll
Okay.
happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. it's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
Yeah, they have to do that.
So there is a footnote. I'll hear you, Mr. Brennan.
Also, for all of you asking about the docuseries, I covered clips of it yesterday. I covered an article from the director. So it is by choice. It is on paid platforms. It is by Discovery ID. I watched it on Hulu. You can probably watch it on HBO or Max or whatever. But also, I would read the interview with the director before watching it, and then teeter in, or watch yesterday's stream. I got you. But I knew it was going to come up, which is why I watched it. And Brennan has brought it up in court now like 3 times. So it's going to come up. For the Kids said that Attorney Little's been with Jackson for 9 years. They seem to finish each other's sandwiches. Like, she knows how his brain works as an attorney. When you work closely with lead
Your Honor, the motion
counsels,
notes that the Commonwealth
you
moves to be partially exempt
get their pattern.
from Rule 14 because of the past
She's
history
also,
of
I think, Attorney Little, finding an attorney that can work arm in arm with you and is great at the things that maybe you are either not great at or don't want to do is perfect. And Little is like the perfect wingman for Alan Jackson. It's just so good. No, not finish sandwiches. Finish each other's. I'm quoting movies, sentences. I have kids, Frozen, but she does a great job of anticipating exactly what is happening in court, what he is going to need, what the court is going to ask for. She's just so incredibly on top of it. And her memory and recall for where things are is fantastic. I love it. And you can see the interplay with defense teams that work well together or attorney teams that work well together and those that don't. Adam Lally had literally no backup. We saw this during the Gwyneth Paltrow case with the Post-it notes going to lead counsel Owen. And I think half the time the Post-it note said, land the plane, my guy. But having a working relationship like that is so tremendously beneficial. We saw it really, really well illustrated in Depp v. Heard. The Depp defense team, I think, worked really well together. We saw a very well-oiled machine in court. Everyone knew what their job was, and everyone picked up and pitched in, but did not overstep. And we saw a lot of tension in the defense team for Amber Heard. They did not work as well together and as smoothly together. So you can see the differences.
perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal.
Okay, provide it to the attorneys under seal.
Protecting the interests of the Commonwealth.
The Commonwealth is being asked, we have to get serious again. The Commonwealth is being asked to provide the discovery information for their witnesses. They've got to turn over contact information for their witnesses. All sides can contact witnesses. I have no problem with them providing it under seal. The public doesn't need that information. Fine. But the attorneys have to have it. We know this, man, come on.
Resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from
I don't have a problem with that. I still need cities and towns.
Of course.
Okay?
Yes.
All right. Thank you. So we will start with it's paper 593, the Commonwealth's response.
Back to motions in limine.
is Paper 610, defendant's motion in limine to allow evidence of lack of bias.
Oh, I've been
Who's
waiting for this
arguing that
one.
For the Commonwealth.
I've been really interested in hearing the arguments on this one.
The Commonwealth first, Your Honor.
No, it's the defense motion. The defense should go first.
Defendant's motion. Mm-hmm. The Commonwealth opposed it.
Yeah, and Judge, you said for the who's arguing it for the Commonwealth? So the Commonwealth stood up and went, "It ain't me, Your Honor." Sometimes you're the one creating the problems. Like when you made everybody renumber the exhibits last trial. Sometimes you're creating the issues
You
yourself.
would ask who's arguing that for the Commonwealth. That's why.
I'm sorry.
Thank
Defense
you,
motion.
Yannetti.
Okay, sorry, I apologize.
Stand up move for Yannetti to step in and be like, you've caused this problem yourself, Your Honor. Good
would
on
ask
you,
who's
Yannetti.
arguing that for the Commonwealth. That's why.
I'm sorry, defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the.
I'm fine with him going.
Fucking hell.
Okay.
Who's on first? The judge apologized. Everybody seems done today. Everybody is done today. Someone just go. Technically, it's the defense motion. They go first. The Commonwealth is like,
the heart of
whatevs.
this motion is that the defense would like to introduce the ARCCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at
it's also
time
true.
they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their
This is
investigation.
for cross-examination.
I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the
No, it
Commonwealth
won't.
does not have a clear
You want to know what
answer.
causes a trial within a trial in this trial? Jen McCabe. Jen McCabe causes a trial within this case. ARCCA does not.
Why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United
True.
States Attorney's Office and ARCCA and what, if any, impact the defense had on ARCCA witnesses at the time they did the investigation.
Cross-examination.
What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case.
Interesting info.
What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCCA witnesses were supposedly tasked to conduct an independent investigation,
is so loud?
and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials
That's
that
for
they
Cross.
weren't given.
That's for
And
cross.
so clearly there is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And
That's
so
for cross.
today, as we sit here, we really don't know. What we know is ARCCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory.
That's for cross.
And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense,
I've
because
got to
I
see
don't
what
think
that
they will
noise
be
is.
able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their
They were, though.
attempts and efforts and report was wholly and entirely objective.
That's
Just to
for
give one point
cross.
that emphasizes
The Commonwealth says that the defense prompted the federal investigation. I mean, I understand that Alan Jackson is a fairly well-known attorney, but the federal government doesn't give a fuck. Like, you can call up and say, we would love you to look at this. It doesn't mean they're going to. It definitely doesn't mean they're going to convene a grand jury. So the power he seems to be trying to attribute to the defense team is not maybe as things would play out. Like, that's not how that happens. I law clerked at the U.S. Attorney's Office in the tax division. We got tips all the time. Sometimes they were followed through. Sometimes there were, in fact, investigations and then prosecutions based on those tips. People get tips literally all day, every day. People want to tell on each other. Someday we'll have to tell stories about who's telling on who in the tax world, because the tea. But it doesn't mean that the feds are going to do whatever. So a lot of what he's arguing is ARCCA shouldn't be allowed to come in here and say that they weren't hired by the defense. But they weren't initially hired into this case by the defense. The defense didn't know who they were until the feds gave them the information. If that's not true, then I think we should see that in court. But Brennan's not said that's not true. Everything we've heard about these experts is that they were hired for the federal grand jury. And then when the feds turned over one of their dumps of discovery, that information was in there. That's just the truth. Cross-examine that. This all goes to cross-examination. But he also knows that if he goes in on the ARCCA experts, he's at risk of looking like a dick because they are very likable witnesses. And if you attack likable witnesses, the jury turns on you. He knows how this works. I'm getting to like, wah. You know how this works. Stop it.
Concern. The ARCCA witnesses were
My
never
white
given
balance is
information
way too pale.
about DNA. And yet, when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains,
That's
how
for
did they learn
cross.
of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial.
Another
before
voir dire?
trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the
If discovery is not
case.
turned over, that might
They
be
should
the
answer questions about,
resolution.
all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but
It's
if
discovery.
we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question
then
these
that's
witnesses,
discovery.
we will learn much more about the relationship. Inevitably, even if the ARCCA witnesses come in to be questioned as they should well before trial, in my opinion, we do not have the opportunity to question
My
the United
white
States
balance
Attorney's
today has made me
Office,
look
who
like I'm a
resigned
member of the
two
Cullen
letters,
family.
which
I never
inevitably
wear white
have been
for this reason.
unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then
They don't say that. They say they were
Commonwealth
hired
will be
independently.
inclined to explain.
Did you not watch the first trial yet? They've never said they were hired by the federal government. They weren't allowed to. They said they weren't hired by the defense or the Commonwealth. That's what they said.
Inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did
Please tell me what you think the court should do. At some point, she should be huffing at him what I think the court should do.
at the first trial. They were hired independently. And then subsequent to that, the defense
Sometimes, Lauren.
retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14
I have
discovery.
more info on that, though.
And inevitably, at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't.
That's what
ask
your
for more
cross-examination
information or why
is
they didn't
for.
receive more information.
Sure.
Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved, and
Is his name on the witness list?
I haven't seen it
No.
on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As
You don't get to
noted,
know that.
That report is vague.
That's on
And so
them.
it doesn't identify, articulate which witness did what. So
I'm just going to argue back. The voir dire at the last trial, they each lined out what they did, including building a cannon. I like these witnesses. So that's where I'm at. I liked these witnesses very much. And I thought they were incredibly helpful in this case. But that's what they did in the last voir dire. In the last voir dire, because the court had concerns that the report wasn't clear on who did what, they came in and did that already.
it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which
Rentschler's
we
the
don't know where
best
the
name
source of
for
that came from,
biomechanical engineer, by the way.
he is not held
So
to
good.
the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will.
That's a
My
fair-
suggestion is to follow the protocol of
The
the last
discovery
trial, but before that,
concern
these witnesses
is a
should be
fair
brought in so
concern.
that we can obtain
Just should have
actual
started there.
records, not just ask them the questions and rely on their word. I think
The
based on
defense,
their
I don't
past
think, has those
performances,
records.
That's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
This is a discovery issue, and a lot of that's for cross.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCCA witnesses became involved in.
Can you remind her that they weren't allowed to testify about the medical cause of injury because somebody didn't have a PhD, but yet the dog behaviorist is now allowed to testify? So can we let the ARCCA witnesses do their job the way we saw in like the Paltrow case? Yannetti, can you bring that up too? We'd love to see that.
In this case, Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial,
Sounds like
this
he's giving his
court
opening statement.
disallowed the ARCCA witnesses.
It's a strong theme of a
from
case.
testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they
Insurance
became
companies.
involved. I think the court will agree that it's ironic in a way that
I think it actually
the court
hurt.
excluded mention of
He's gonna get there. I think he's gonna get there. I thought it was helpful to the defense to say that none of them hired, but what we've seen in the interviews jurors have given is that it actually kind of hurt those witnesses because we had more information than the jury did, and sometimes it's hard to filter that out of your brain. And the jury was trying to fill in the gaps about who would hire them, and we're starting to fill in the gaps about insurance companies and what have you. So it's helpful to the defense to know what the jury was thinking so they can try to fill in those gaps a bit more, but without being able to say the federal government hired them, which I do think could be too prejudicial in this case. It left them in a weird position where they're like, we didn't hire them, the Commonwealth didn't hire them, but then the jury is going to come up with their own answers, and those answers are probably not going to be right.
of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate
And then they did speculate.
a federal investigation. But by excluding mention of the federal government having retained ARCCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And,
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that.
That makes sense that they would speculate
if
that.
Ms. Reed's insurance company had hired ARCCA, they would have had a motive to absolve Ms. Reed of responsibility.
Right. People
They
look for
clearly
answers.
That clearly would have.
Humans look for answers. It is one thing that I consistently watched people fight with during law school, and I have seen many struggle with when covering these cases. People want answers. I get frustrated when we get to the end of the process and there's no answers, but I try to trust the process that there will be answers at some point. But people get frustrated and want answers, and they want to close the loop and fill in the gap. And if you leave a gap, you can't control what they fill it in with. So when you get to the end of a 10-week trial and they're talking about these experts, it's like, okay, well, who did it? Who answered it? It's even hard to wait for a verdict. How many of you waited for, what was it, 5 days for a verdict in this case? Day after day. And we're like, oh my God, where are the answers? A lot of you feel that way. We get closing arguments, jury instructions, the jury goes back, and we're sitting here going, tick tock. You've been back for 15 minutes. What are we doing? Where are we going? Do we have a verdict yet? We are humans. We want answers. We don't want to leave the unknown lingering. So I get it. I get it. They're told not to speculate. Oh, okay.
Adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that
I don't think
the federal,
that's gonna come in.
How does that not open the door
For
to
a
all
fucking
the
shit show.
testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you
court's like,
answer
answer
that
that.
now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you
if-
just
if
said
I
it's
could-
late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
The judge is telling the defense, we told the jury not to speculate. And the judge is like, okay, but I have a question now. Can you speed up in your argument and answer the question I have now? I'm not going to write it on a notepad. I want the answer now. And he's like, I'm fucking getting to it. Just like the jury. Your Honor, don't speculate. Let the man finish. Oh boy, I'm going to just back that up and let that play out in real time.
Responsibility. They clearly would have. That
He's so
clearly
done with being
would have
interrupted.
adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question.
No.
If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you
if-
just
if
said
I
it's
could-
late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Me and my husband, when we're hungry and we're trying to figure out what to do for dinner. That exchange. But you just said you didn't want.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice
It becomes
my
a
client.
black hole.
Thinking that they were potentially hired by an insurance company of Ms. Reed.
they can ask questions around
really
that.
perverts the truth in this case.
But it becomes a
it's unfair
black
to my
hole.
client, and it's the opposite of the truth. There was another juror that speculated that the ARCCA witnesses were just attention seekers, looking to make a name for themselves.
I didn't hear that.
In a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them.
They were called because
That's
they're
how
good
the
at what they
Department
do.
of Justice wanted it.
And they
They
work
wanted
for...
clean experts who would take a sober and strictly scientific look at the evidence.
Wait. You're telling me that the U.S. Attorney's Office did what prosecutors are supposed to do and try to figure out what the fuck happened? And they went to an expert and said to the expert, hey, you're an experty expert. You work with like the NHL and the military, and this is your shit. This is what we know. Can you tell us what the fuck happened? Thanks. It's like somebody was looking for answers. And I think the jury should hear that.
Federal prosecutors did not want them to be tainted by news reports or opinion pieces.
They just
And
wanted
recall
to say what
that
happened.
the Commonwealth attacked ARCCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball.
Jordan, we'll get this at a
When
break.
that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got,
Jurors often think that the defense is
Mr.
hiding
Brennan
things.
engages in
It's
a
kind of
ton
ingrained,
of speculation about what happened or
unfortunately.
didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose.
Your Honor, we're the defense. The discovery we get in this case, the police reports, that comes from the government. And if the government, in this case the Commonwealth, or the DA's office, or law enforcement, or whatever, is a target of the investigation, they're going to get the case file from someone else. The feds asked for my case file. We have nothing to hide. We sent it to them.
What to give ARCCA or what not to give ARCCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them
To give them
truth.
answers.
We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was
That's what I
complied
thought.
with. And all of a sudden it was revealed to us that the federal government had hired these ARCCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them.
I
The
wonder
Commonwealth
why.
Court chose not to contact them because the information was exculpatory.
I have never seen a case where there is an ongoing federal investigation like this paralleled to a state level prosecution. I don't know if there's ever been a defense team that has had so many things helpful to them fall into their lap because of a federal investigation. It is wild. It's just not real life. This does not happen. So where the ARCCA experts came from is not exactly a topic that people have had to tackle before, because this just doesn't happen. It's so bizarre. I can't imagine how the defense responded to seeing those results for the first time. Can you fathom it? Because this just doesn't happen. And they are good witnesses, I think. And they are helpful witnesses, I think, to try to get to what happened.
The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material.
That's what I said.
He's free to explore whatever he wants on cross-examination.
Well, not whatever.
So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decision.
You never
and
get
what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing.
Then
Now,
cross-examine them.
I didn't know
That's
that
for
Attorney
cross-examination.
Genetti's file was subpoenaed. That's new to me.
It's new to
Perhaps
us,
the
too.
Commonwealth knew. I've never heard that before.
You don't need to hear
I
that.
don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now.
If you're not invited, it might be because they're talking about you. Just saying. It was true in junior high. It's still true now.
Now that Mr. Genetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government. And
I mean, they
chose
weren't talking
whatever
about
they
him
chose.
specifically, but
This report by
the office he now
ARCCA
represents for this case.
was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Gennetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to.
That's
I'm
interesting.
not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was
But there's discovery.
obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have.
That's
As
discovery.
you've seen from the ARCCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence.
For the DNA thing's about cross-examination, but saying that there's no relationship with the defense, if the federal government hires an expert and gives that expert shit to review, which is how that works, and then they review that shit that's given to them by the Department of Justice attorneys, the AUSAs, they don't know where that information came from. Just like when you put Trooper Paul up on the stand, he's looking at the police reports written and produced by his police department. That's the information he was given. And then the defense gets up there and cross-examines the witness just like you do. He's taking, that's literally how this works, and being like, but Your Honor, they only reviewed some things. And then on cross, you say, but you didn't review this and you didn't know this. Where are we even? The purpose of this motion is that the defense is asking, and he's gotten very far afield, and he keeps trying, I think, to distract the court, and he keeps going off on side quests. The purpose of this motion is, Your Honor, we want to be able to introduce how the ARCCA experts were hired so the jury doesn't speculate. And Brennan is on a side quest of, but we don't have the discovery.
Evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility.
That's
I don't see that in these
cross-examination.
transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses.
No, it
It's
won't.
unnecessary.
That is
It
so
can be resolved
hyperbolic.
through questioning these witnesses prior to trial and following the same protocol you did last time.
He wants a voir dire.
All right.
And if the court's inclined to leave a gap from jury selection to when this case starts, she might give them the voir dire. She might give them the voir dire. Because there are some discovery issues, because there is a giant wall where the feds are concerned of shit they're not going to turn over and shit that the experts might not be allowed to say. But now that the federal investigation is done and closed, there might be things that the experts can disclose that they couldn't disclose the last trial. So there might be a voir dire on discovery issues to try to step around this, because I think that might be the cleanest way to handle it. And I don't think that's unfair to either side, because it's different now that the investigation is closed. But the feds aren't going to help here. The federal government is like, good luck, staties. We do our own thing.
So if the defense intends to call the ARCCA witnesses, we need to have a voir dire next week. All right.
Next week, Your Honor. I'm traveling next week, Your Honor. Emily, just keep watching.
We're going to move on. I'll take
Next
this
week.
under advisement.
Can I just ask the parameters of
Can
that?
I just ask what the fuck? The ARCCA experts are going to testify. You want a voir dire next week? Girl.
If the defense intends to call the ARCCA witnesses, we need to have a voir dire next week. All right? So we're going to move
said
on. I'll
what?
take this under advisement.
Was that
Can I
Elizabeth
just
Little
ask
going,
the
what?
parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14
Rule 14.
information.
Discovery.
We can discuss this later. Let's move on, and I'll hear any objections.
No!
later.
Can we discuss it now? I have never heard, and I think that was Attorney Little, I have never heard Attorney Little sound so dejected. What? Girl, all of us. All of us. Also, yes, I'm teasing about my schedule, but I am traveling for a YouTube event
All right,
next week.
so the next
Because we didn't have court next
Motion
week.
is the defendant's motion.
Also, Alan Jackson is like, I was planning on going home.
For stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Your Honor, it sucks to not be able to state grounds for objection, and the online legal commentator
Yes,
lawyers
I
hate
believe
it.
my written submission essentially makes the argument, Judge, but,
Okay.
During the last trial, as a result of our inability to state in, one or two words the basis for an objection.
Grounds.
We had to go to sidebar far more often than we'd like to. And we're also conscious of the
sidebar.
fact that, we have a jury sitting for weeks at a time.
That's there.
away
I was just trying to figure out if the sirens were here or there, so sometimes I will pause because I can't tell. It's there.
from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So,
Oh, that's fair.
There were many times during the
It's a fair
trial, I
consideration
won't
for the
speak for my
defense.
co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection.
The objection spoke to her. Again, it is bizarre to me, and I don't know how a judge would do it. It is bizarre to me to just say objection. Sometimes it's really obvious, sometimes it's not. It makes it hard to preserve a record. It makes it hard to argue the objection. It makes it hard to say, now can we go to sidebar? What the defense is concerned about is the jury perception that they're the ones delaying things, and that is a real concern. Jury perception is a part of trial strategy. And so if the defense is constantly going to sidebar saying, Your Honor, can you explain to me WTF you're thinking? Respectfully, it's frustrating. He's right about that. So if somebody just says objection hearsay and the defense is like, okay, we can ask it a different way, or objection compound or whatever, then they can either choose to go to sidebar or choose to rephrase what they're doing. When they don't know what the court is thinking, you can't work with it. No. Okay. It's like fighting with a toddler. What are you upset about? And they just scream at you. You're like, okay, well, I don't know how to help you. Like, are your shoes making you mad? Are you hungry? Do you need to poop? I don't know what's happening. Can you give me a hint? Spell it with your P's.
And I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know it.
I agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary
And sometimes
rules
you can just
whatsoever.
work around it.
But in any case,
And not go
this
to
will
sidebar.
avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender
breaks up the
hostility
flow.
from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We
Also
think
need to
that
preserve
this
for
would,
appeal.
and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no trying to coach a witness or, trying to influence a witness in any way. And that's not.
My guy, you're going to push it too far. I don't think we need speaking objections. I think we need grounds. Speaking objections between this prosecutor and Alan Jackson are going to be a mess. And I wouldn't trust Brennan with speaking objections. I don't always trust Jackson with speaking objections either. Grounds, though. Just grounds. Just grounds. I think he's reaching farther to give her the middle ground of allowing them to state the grounds. No speaking objections. It's going to be a mess.
What we're seeking to do here, the objection hearsay, the objection lack of foundation.
Grounds. Those grounds.
Just standard basic
legal grounds.
objections
That's it.
There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, defendants.
I hate that ruling. I hate it so much. This annoys the shit out of me. For those of you in the chat asking, what are speaking objections? Speaking objections, different than stating the grounds for the objection, different than just stating objection. This court allows a party to say objection. That's it. And on appeal, it preserves all possible proper objections. That's what it does. But the strategy of what makes it difficult for the attorneys is what you just saw. This is what this judge does. I hate it. Speaking objections go beyond the grounds. But Your Honor, this witness is speaking objections can open up the door for argument in front of the jury, for statements and theatrics in front of the jury. And we've seen some of that in trials that we've covered. But Your Honor, they know better. And the grounds are what? Hearsay? The grounds are just the legal grounds from the Code of Evidence. Compound, hearsay, leading, facts not in evidence. And it is a difficult pattern to get in if you are used to speaking objections. If you're used to saying improper question. Yes, all of you are like Carrie Morrissey. Yes. And you end up in a pissing contest with the attorneys arguing in front of the jury, giving the jury A, a show, and B, quite a lot of information. But when you just say hearsay or what have you, it at least gives everybody the foundation of, do we need to go to sidebar and argue it or not? It's this judge's practice. I do not like it. So the legal grounds for objection are not stated. They just say objection. But again, that's not just this case. This judge is not changing her practice for this case, but it seems to be her practice across cases. I just don't like it.
Motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the
Let's
Commonwealth
talk
intend to
about
put this evidence
Proctor.
into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti.
No objection, so it's allowed. We're moving on to motions in limine. More motions in limine.
False and irrelevant statements of Michael.
So this is a defense motion to exclude some statements of Proctor.
In the first trial.
Okay, that motion is denied. So the next motion, defendant's motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti.
So that's granted.
There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion
The
to
dog expert.
exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal.
No. We have moved on now to the defense motion. This is not technically a motion in limine. This is a motion to reconsider. The defense motion to reconsider the ruling with regard to the dog behaviorist. At the first trial, and I think the judge ruled off of vibes. At the first trial, the judge very clearly said, in Massachusetts, if you are going to testify about the medical cause of injury, you need to be a motherfucking doctor. I'm paraphrasing, only slightly. And so the ARCCA experts, who are, I think, both biomechanical engineers, one might be a biomedical engineer, were not allowed to testify about what they know about the way that brains and skulls operate together, even though that is a large part of their work. They talked about their work in making hockey rinks safer regarding head injuries. They talked about their work making military vehicles safer to reduce head and spine injuries. They talked about quite a lot of work that they do to engineer things that protect the brain from sloshing around inside the skull. So that is their world of expertise, but not doctors. She wouldn't allow it. Then she ruled that the Commonwealth's non-veterinary dog behavior expert could testify about the injuries to victim John O'Keefe's arm and whether or not those were caused by a dog. Injuries to a body seem to me to be in the realm of medical. So if there is such a rule, I'm pissed about this ruling. If there is such a rule in Massachusetts, you must be a doctor, then how is this non-doctor testifying? If that's not the rule, why was it the rule during the first trial? And where did the rule come from? Vibes? Statute? Case law? Where's the rule coming from? But if that's not the rule, then it's not the rule for all of the witnesses. It can't just be the rule for some of the witnesses. This ruling makes no fucking sense to me at all, and I hate it. Because either you must be a doctor or you don't have to be a doctor. But the injuries to an arm and the injuries to a brain are still injuries. So which way is it? So the defense is asking the court to reconsider. And no one in their motions talking about this has cited to statute, has cited to law, has cited to case law. And if there was something to cite to, I trust that Alessi would have found it and would have cited it. I don't think Alessi's going to hide the ball. I think Alessi would say, this is the case law. Here's how we distinguish it. So the defense is asking the court to reconsider that ruling.
Before the witness is called, so we don't need to do this now.
I think we do need to do this now. The court's going to say, we can do this later, but I think it impacts other witnesses.
Denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is
I'm backing up. All right. Defense motion to reconsider. I ranted.
Defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is
I love that he loves the remarkable as much as I do.
I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor.
Are we sure that the Commonwealth is calling that witness in rebuttal? If the Commonwealth is calling that witness in rebuttal, then fair. But I have questions. So the court is saying if this is a rebuttal witness, we can deal with it after Dr. Russell's testimony. So I just want some clarification on that.
And also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after Dr. Russell's testimony.
Okay.
All right, there's a motion, it's 599. Defendant's motion in limine to prohibit the Norfolk District Attorney and
All right, we're
Massachusetts.
going to back up. That's not a no. That is a, after Dr. Russell's testimony, things may change, and we will talk about it then.
State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion
They just
eliminate
want
to
it said
prohibit
out
Norfolk
loud.
DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you
Probably
think this
Alessi.
might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay.
Fair.
Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alessi says, but I can't imagine it's more than
Alessi.
15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick. That I just wanted to know if the defense had objections to.
She went through the defense's motions in limine, reserved this one, and is going to zoom through the others to get them done, and then is going to circle back to the one that
To
needs
appoint
longer
a
argument.
stenographer, we've already done that.
And we'll probably take a
Prevent
morning break before
identification of
that.
jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
So we're now moving into the Commonwealth's
Thank you.
motions
Which
in
motion,
limine.
Your Honor?
It's your number one, 575. Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
I mean, that just happens. Why do we need to talk about it? Just like, yes. Why are we, what?
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors, this case is a case
Just
that has
impound it.
garnered
I don't
extraordinary
think anyone's
public
going to.
interest.
Okay.
There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
No, that's what they did last time.
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that,
already
I
did
guess
that.
I would first ask whether
They did
Mr.
that last
Brennan is
time.
pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
I mean, everything was
So
impounded last time.
Sidebars are impounded regarding jurors anyway.
Right, so we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar
I mean, that's what you
discussions
did last time.
regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well,
on
that's what I'd
things
like
that-
to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a new
change.
trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position.
You
for
did
this.
it last time, but you did it after trial. The judge keeps saying this is a new trial, and Yannetti didn't miss a fucking beat to say this is a new trial, I've been told. Yannetti has a different, a subtler style than Jackson does, but that is hilarious. Also, the sidebars were impounded, I think, at the end of trial last time, if I remember correctly, but this is a new trial, I've been told. He's tired of getting interrupted, so he's giving it back a little bit.
So we do question the impoundment of all
funny.
sidebar discussions.
Okay, you
love it.
agreed to it last time, right? So this is a
This is a new
change.
trial, Judge.
Right,
I've
no,
been
so
told.
just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the
For all
reason
of you
some discussions
asking
are
about
held at
FTR, it's the
sidebar is
live
to prevent
transcriptions.
jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But
The reason this matters day to day is because, in theory, you could order daily transcripts if you are a member of the public. I mean, it would cost thousands of dollars to do so, but in theory, you could order daily transcripts and have access to the sidebars. I don't think anyone did that last trial. The sidebars are impounded from the last trial still. You can impound parts of sidebars, but not all of them. But people could get daily transcripts, or if the parties had daily transcripts and the defense might pay for daily transcripts, then they have access to that as well. And so some of it might be sealed, some of it might not be sealed. Massachusetts calls it impounded, but he's arguing that not everything at sidebar should automatically be impounded.
Prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information. But the court's able to guard against the
If
jury.
somebody's getting daily transcripts, my email's public. We'll go over them. Am I going to buy them? Probably not.
Being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch
But I'll
or
take
pay
'em.
attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for
What's
me
the bracelet
sealing?
stack? I do have questions. I like the bracelet. I like the bracelet stack. I want more shots of the bracelet stack.
Or impounding sidebars?
Yeah, Commonwealth. Why impound it all?
I
Why
don't have
impound
an
it all?
answer to that. It's something I'll need to look into because it is.
It's your fucking motion. It's your motion. Are you kidding me? Your Honor, she knows what's coming. Look at her face. She knows what's coming from Brennan. It's your motion. Vibes, Your Honor. Vibes. I like that he goes back to the podium. I like that he goes all the way back to the podium to be like, I don't have an answer.
So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
The vibes. What's the authority? What's the law? What's the statute? How can I do that? Cartman, respect my authority.
I don't have an answer to that.
Shit.
It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it.
Then why is it a
I
concern?
can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's
But the jury
concern.
doesn't hear it.
Even the most diligent.
But the jury doesn't hear it. He's saying we think the jury's looking at the media and we don't want it reported. There's a bunch of shit in the media that's not going to come in before the jury in this case already.
Should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news
That's
reports or not.
not a
whether they're
valid-
simply getting lunch. If there's
Then they
evidence that
have
is
to bring it
deemed
to the court.
inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive
Stifle?
the community of the full value of the public trial.
It is completely hypocritical of me to criticize anyone's pronunciation of anything. I am aware of this. It does not slow my roll. Did you just say stifle? I understand that when I mispronounce names, places, and all the rest of it, that it is nails on a chalkboard, y'all. I get it. But stifle? We let nefarious go a little bit because it had like a villain vibe and it's kind of funny. It was very Dr. Nefario. But stifle? Counsel. You're killing me today. First of all, what's the authority? I don't even know, Your Honor. But we don't want the media to say shit that the jury who shouldn't be looking at the media might hear that we don't like at sidebar. Because we don't want to stifle the First Amendment. What?
Trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would
And
be
they're
prejudicial or
admonished.
extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court.
Some of the cases about media access to courts go back to like the late 1800s, early 1900s, because the newspaper used to print photos and addresses of jurors in cases, in high profile cases, when they were talking about them. So do not come up in here and say it's a cottage industry. As long as people have been, sharing information with one another, they have been talking about what's been going on in their community. Local papers used to do that solely. The distribution channels have changed. The human desire for chisme has not. So don't act like it's a new thing. It's a new mechanism, but it is not a new thing. Brennan. And you should know the case law on that. It is old school cornerstone law.
Whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
There's not going to be authority for that.
Is there an objection?
I grew up in Southern California,
It's
so
577. It's the
There's
Commonwealth's
no-
Exhibit 3. Motion 3.
There's no accurate English equivalent to chisme. There's just not. Yes. There's no appropriate one-to-one. Gossip doesn't do it.
Commonwealth's motion for
T is not
in-court
enough.
identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one.
I feel stifled, Your
Commonwealth's
Honor.
motion eliminate to admit the victim, one photograph of the victim, two photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that, Ms.
objection.
Little? That's allowed.
Yes, she's
578.
banging through the administrative stuff where there's no objections.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579. Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate.
The Commonwealth brought this in through, well, maybe they didn't. The defense might have brought it in, but this came in through Dr. Scorti-Bello last time. So this is the Commonwealth trying to keep out the manner of death. I don't think we're going to see that, but trying to keep out the manner of death. The manner of death in this case is undetermined, which makes sense given everything we know about the case. I thought the medical examiner testified very neutrally. I thought the medical examiner was good. Eva said Kiki comes pretty close to Cheese Bay, though my connotations, and I might be wrong, I always put Kiki with like more of a conversation. I don't always give the conversational component to Cheese Bay. Maybe I should, but either way, Kiki is close, but T. Tea with a side of flair. So the Commonwealth wants to keep out the manner of death undetermined, and that's what this motion is about. It came in at the last trial. I can't imagine what their grounds are.
I'll hear you on that. Yes.
So this is the Commonwealth's motion in limine. Remember, the motions in limine, this is their purpose, to sort out these evidentiary issues and questions before the trial
Pursuant to
starts.
Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our
Oh,
memorandum.
look,
We
authority.
would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses at a call regarding the manner of death,
Then why redact it?
but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19.
You charge this as a homicide case. You charge this as a homicide case. You charge this as a homicide case. So on this, you get what you get and you don't get upset.
Provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall
Also,
be admissible in evidence.
Don't put the death
Again,
certificate
different
in.
from question-
What? Why would you put the death certificate in evidence? The death certificate doesn't need to be evidence. You just bring in the coroner. I'm going to let him finish.
Questioning a witness that is offering an opinion regarding the cause of death.
Because it comes
But the
in through the
certificate itself
testimony.
Should be redacted.
Okay. He wants the
And it should
certificate only
follow,
redacted.
Massachusetts general laws, and it should follow Massachusetts case law.
I don't even know why
reasons.
this certificate's
We ask
evidence.
the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor.
Again,
In this case, the medical examiner who completed the death
Will testify
certificate
to it.
concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks
I don't know
not
why they're
only
putting
to
the
have the
death
court
certificate
redact
in
the manner of
evidence
death
anyway.
here,
You
but
just
they're
need the
also
testimony.
not calling the medical examiner in this case, which creates certain issues.
Girl, what did you just say? Miss Little, did you just say that the Commonwealth isn't calling the ME this time? We're going to back that up. We're going to... What? That's why they want the death certificate. She is on the Commonwealth's witness list. We went through the Commonwealth's witness list. Dr. Scorti-Bello's on there. It makes a little bit more sense now. The Commonwealth wants to redact. This is my real-time processing of what we're learning. The Commonwealth wants to put the death certificate in evidence under a business records exception, I would imagine, without calling the medical examiner to testify. They buried the medical examiner towards the end of the case last time. Without calling the medical examiner to testify. The defense is just going to call the ME. I think it makes them look worse. If you are the prosecutor trying a homicide case and you have a medical examiner, I understand if the medical examiner is deceased or something and there is a reason you can't call the ME that did the autopsy, then again, I've seen cases where people will call the reviewing medical examiner if the medical examiner that did the autopsy is not available. It happens in cold cases where the reviewing ME comes in. But if you are standing up and trying a homicide case and you don't want to call the medical examiner because that testimony is not helpful to your case, why the fuck have you filed a homicide case? I am now literally eating my microphone. If the prosecution in South Carolina could call coroner armpits, you don't want to call Dr. Scorti-Bello because Dr. Scorti-Bello said this victim died of a head injury and hypothermia. There's a lot of ways that head injury could happen, but you would need a biomechanical engineer to talk about how that injury happened. And then said, no, we don't see the regular indicia of a car accident that I have seen in other autopsies I performed on car accidents. Commonwealth, this is your evidence. You filed this case. This is your medical examiner. And you don't want to call the ME? Holy shit. I'm backing that up. That's why they're fighting. Me sitting here going, why are they fighting over the medical certificate? This is why they're fighting over the certificate. This is why they're fighting over the death certificate. They want to use just the death certificate. If you're sitting on a jury and a prosecutor is sitting there telling you that this is a homicide, this is an intentional murder, and they don't put on the coroner and that coroner is available and the defense brings in the coroner, what is your first thought as a juror? Because mine, I think, would be, what are you hiding? This is fucking bananas. Well, now we know why Dr. Scorti-Bello is on everybody's witness list. This is going to be very interesting. This is going to be very interesting. You know, chat, let me know what you think. We've now seen Brennan in court a number of times. His demeanor in front of a jury may be different. For those of you who watched Lally in trial versus Brennan, and you know the issues I had with Lally. And there were times that I didn't like what Lally was doing. But Lally came across to me as more, I don't want to say inept because it's rude, and that's not how I mean it. Lally didn't come across to me as intentionally, volitionally shady. That was not the vibe. The vibe was like, somebody made me fucking be here today. I don't even want to be here today. So we're just fucking doing this. It's like somebody handed Lally a leash and was like, walk the dog. And he's like, yep, I'm just doing my job. I'm clocking out after today. Lally came across as like, I got to do this, so I'm going to do it. Not a lot of energy for it. Not a lot of fire behind it, but like clock in, clock out. That was the vibe from Lally for me. Kind of just, I don't even want to be here today. Brennan's not going to come across that way to the jury. Let me know what you think. Brennan's not going to come across as, I'm just doing my job. Brennan's vibe is completely different. And if Brennan's demeanor in front of a jury is the same demeanor we're getting in court, it's not going to read as, oh, well, to the jury. It's going to read as the prosecution is hiding something. That's my opinion. He comes across much more like a shark. And juries pick up on it. Lally is not a shark. I think Lally might be a lobster. So Brennan comes across as a shark. And the jury is going to be able to see it. And if you don't call the fucking coroner, holy shit. All of you have taken issue with me calling Lally a lobster. I'm not trying to name call. I'm just saying. He's got kind of a hard shell. He seems like he's probably a pretty loyal dude. He's like, I'm in it for the long run. And he's just kind of going along. Brennan's a shark. This is fucking wild. I mean, when we're talking about predators versus prey in the courtroom, there are prey attorneys and there are predator attorneys. Somebody said, I've never heard that lobsters are loyal. We're getting back to like, he's her lobster. We've got all the references today. This is fucking bananas. Holy shit. That's the headline for today. The Commonwealth isn't calling the coroner.
The medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth
fucking
in this
wild.
matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments of the United States Constitution.
Different.
That is not the situation
That's very
that we're presented
different.
with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis,
Wow.
I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate.
You guys have a ton of questions about this. I am grabbing them as fast as I can. We'll get to them when I get to questions, because I want to hear the rest of her argument. But you guys have great questions, so I'm holding on to them.
And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate.
Your Honor, the Commonwealth is so lacking in authority that we have to turn to dicta.
Homicide, suicide,
Wow.
or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from
That
a
makes
death
logical
certificate.
sense.
The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought.
The medical examiner is on the witness list, but did you hear the court go, wait, what? The court's like, wait, what? Wait, what? I also might have ranted. Maybe the Commonwealth is going to stand up and clarify, and maybe I've ranted improperly, but she's on their witness list. But the judge is like, I'm sorry, what? I will say, because she is on the witness list, that they have to prove that John O'Keefe died. They do not have to prove, well, they have to prove that Karen Reed's car caused him to die. Doing that without an autopsy is difficult. Just having and he's dead is wild. All right, let's continue on.
I saw her. Dr.
She is.
Scortibello?
Dr. Scortibello is on the witness list. She is. Elizabeth Little's like, no,
Not
she's
on their
not.
witness list.
Yeah, she is. I saw it. Brennan's looking down the road like, what do you mean she's not? I'm going to pull up the witness list too, because I saw her on there, because you guys asked me about it and we went through it. All right, Emily, go find the witness list. Let's see who can find it first. As everyone sits down at their computers.
On the Commonwealth's witness list.
Yeah. It's there. Brennan, are you calling the coroner or not?
I'll take this under advisement. I'll take a quick look at Ellis again.
Did I rant improperly? Maybe. The argument, the legal argument from Attorney Little, because Scortibello is on that witness list. The legal argument from Attorney Little is that death certificates are redacted per the case law when the manner of death is homicide, because that word means something different to the coroners than it does to a jury. But it can make a jury go, oh, well, if the coroner decided it's homicide, why are we here where a jury murder happened? What homicide means for a coroner is not a criminal determination. And some coroner's office, I think, have started changing that a little bit. But when you're looking at manner of death, you're looking at homicide, suicide, accident, natural causes or natural, and then undetermined. Those are it makes one of those. But it makes sense to take homicide out because it can influence a jury in making a determination. That's very different than leaving undetermined or undecided that lets the jury be like, we don't know, we need you to decide. We can't decide, we need you to decide. Okay, maybe they're not thinking about not calling the coroner because it is on the witness list. And if Attorney Little's argument is based on the fact that she didn't see Dr. Scortibello on the witness list, not on other information, then that's just I missed it on the witness list. But it's on the witness list. That witness is on the witness list.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
Attorney Little, we stand. She's like, okay, if it's on the witness list, it's coming from this.
At one point, they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion eliminate to introduce certified records from the Registry of Motor Vehicles.
Okay.
Is there an objection
So that came
to
from a
that?
representation.
Ms. Little?
No objection.
Okay.
That'll be
Probably
wild if they
one
don't call
more
the ME.
quick- So that's paper 580, Jim?
Thank you.
Commonwealth's motion eliminate with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that, Your Honor?
Sure.
All right, we're getting into another motion eliminate.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire precisely because the answer was clear and
This
was
is
given
about
under
pulling
oath.
criminal records
It
from the
is
jurors.
solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious.
That's
about
not
whether the
outside your
potential
house. That's
juror is
outside the
telling
courtroom.
truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case,
Oh boy.
stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Well, yeah, if they're pulling criminal records, they have to be turned over because the defense doesn't have access to that. Brennan's like, is it though? What do y'all do?
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, there may be people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. It, I understand, may have happened in this case, has happened in many of my cases, and the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all, too, to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up, and I specifically say, perhaps your experience as a witness or a juror.
Erica, it happens.
Or a defendant in a criminal case.
It happens. Erica's like, how do you forget if you have a criminal record? It happens. People, there's also issues with expungement. People have old misdemeanors and they're like, oh, I thought that was gone. I didn't realize that that was still there. This happens all the time. This happens all the time. It's like, oh, I thought that thing was gone, especially with misdemeanor cases and how they're reported on rap sheets and stuff like that. It really is more common than you would think. It just, yeah, it happens. People forget. So people forget. And yes, but a lot of you in the chat were like, wait, what? Yeah, it happens. Yep, absolutely happens. So, and the judge is like, I also give a catch-all.
Or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar.
And sometimes people don't know what
every
counts.
trial there's somebody that says they forgot to say something, or they had a record that, you know, got in trouble when they were 17 or
And they don't know
something.
if it counts on
So
a record or
happens.
not. If
And that's an argument against the Commonwealth's motion, because you're
But I
giving the
thought-
jurors a chance to correct what they put on the initial form, there's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
Perfect. Morning break. And I have ranted enough today that we should be able to get well past the morning break and back into live court. And that's
You
exactly
are
what we're
muted.
going to do. They're going to take the morning break and then come back in to argue the defense motion to exclude Dr. Welcher. So let's zoom and get right back into Alessi. He says he's got about a 45-minute argument.
Before we begin,
We'll stop with that. Jace asked, is something like a speeding ticket a criminal record? It depends. It depends on the jurisdiction. It depends on the ticket. So there are traffic cases that can be out of the infraction world into the misdemeanor world. And that is so different by jurisdiction. But yes, there are cases where traffic infractions can be, or traffic violations can be misdemeanors and can be on a criminal record. It really just depends.
realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCCA witnesses next week. We'll have it before they...
Well, Your Honor, where are our clappy hands? The judge is like, I have checked myself before I wrecked myself and realized that next week is going to be a mess. So we're not going to do that. Thank you, Your Honor. That's much better. Good Lord.
Realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery.
Oh, the Commonwealth's
and
not
see
going to be
where we
happy with
stand.
that.
So we don't need to bring them here next week, unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined.
The Commonwealth's not going to be happy with that because the Commonwealth wants more time. And she's saying, we can do the voir dire the day before they testify. The Commonwealth wants that information now. This gives everyone more time and gives the defense and the witnesses more time. The Commonwealth, I think, will be annoyed with that.
Find on what issue is before the court that would justify a voir dire. I just
Rule
want
14.
to make sure. I don't think that's
Discovery, we've been over this.
been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
She did say
Does
that.
that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony,
Told you.
and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
AJ
So
should
see
have
where
just
we
let
stand.
Alessi
If
go.
we need to address it, we'll address it before.
Alessi and the court are on the same page with that.
discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information.
He's trying to embiggen what he's asking for.
I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell
The
me
court
before we start the trial where you stand.
Sort it out.
Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion,
The court.
Mr. Alessi.
Sort it out. It's going to be interesting seeing Alessi handle all of the experts this trial. Sorry, y'all. I'm fighting with my desk today. Mama Bear is on the same wavelength with me about my Lally Lobster analogy.
May it please the court. In my presentation today with regard to Dr. Welcher.
Just to reorient, we have gone through quite a lot of motions in limine today. The court has really moved through a substantial amount of motions. We are now getting into argument on the defense motion to exclude the Commonwealth's witness, Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that?
I love it when he does that, Your Honor. Leave Alessi alone. He orients us to exactly where he is in the argument. He gives us an outline and then he follows the outline. Let him be.
May it please the court. In my presentation today with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me.
She says it with a
Do
smile,
you plan
but
on doing that or are you just outlining it?
He's just
I do
like,
not, Your Honor.
God
Thank you.
damn
Go
it.
ahead.
In my
God damn it.
presentation today, Your Honor, I'm going to
He's annoyed. You've annoyed Alessi. She is joking with him. He's not taking it well today. Because he's like, look, man, I have brought my discussion of quantum physics down to a discussion of arithmetic. And you're going to give me shit about the way that I'm doing it? Not today, Judge. That's where he's at. She's
Just
trying
so
to tease him.
Your Honor has the
He does not want to be
documents
teased.
in front of you that I'm going to be referencing. I'm going to be referencing the 140
He's like,
slide
we're not friends like that.
presentation.
Okay.
What the Commonwealth has dubbed a report.
I think she likes him, and that's why
which
she's
is
teasing him.
approximately 12 pages of
He's
a letter
not
dated
amused.
January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his math any common acceptance or any of the Dalbert factors. And this, again, is a pattern of the Commonwealth. They provide long CVs, long qualification lists, and then are completely silent.
I saw the buffering too, you guys. Apologies. It's on my end. There is weather. There is spicy weather. It should, if you refresh, be back. Hopefully it is back. But I froze briefly. We are back. It's not you, it's me. And Alessi is just laying out the Commonwealth's pattern of proffering experts that do not go through their methodology.
On the tethering of the methodology to a common acceptance or the Dalbert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000.
You guys, I love Alessi. So he also speaks methodically. I'm going to put him at 1.25. We know what he's talking about. We're going to put him at 1.25. And I saw questions about my internet. I have the fastest. Ralph, I appreciate it. I have the max of what is available where I am, but today we have spicy weather and Mercury's in retrograde. This is the best feed we've had out of court all day. This morning, the court feed out of Massachusetts was a mess. And yeah, there are times that weather is just weather.
And
That I have
I'm
not
going
done. I have
to
not gotten Starlink.
provide 4 parts
I can
of
look at it.
Canopy.
Nick
Number
Guy
1,
video said
it's
Starlink.
in head
I'll
note
look.
11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth.
We're at
a party
1.25.
proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf, and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative, that's the ipsi dixit.
You're Alessi to the ipsy dixit again. To the ipsy dixit again. Ipsy dixit again. For all of you talking about Alessi's demeanor, I have him sped up at 1.25. So we cannot well assess demeanor and speaking tone because I have him a little sped up because he does speak more slowly and thoughtfully. And he said it's going to be a 45-minute argument. So I put him on 1.25. So as a reminder, he is a little bit sped up. But we got to the ipsy dixit and look, it almost got spelled right. And he spelled it out for chat. Last time we got to ipsy dixit, he didn't define it. I wonder if he thought the court needed the definition. He was like, we're getting to the ipsy dixit. And he said, that's not my pejorative. That's what is in the case law.
To pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative, that's the ipsi dixit, comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this.
I love that he got to perseverate. He's saying the argument of the expert is the result is this because I said so. Because I said so. So that's why he's using ipsy dixit. Because I said so. Is anyone ever satisfied with because I said so? No. But he's saying the problem with this expert is the expert's conclusion is, well, because I said so. That is why he's using ipsy dixit. Go ahead. Next time you're just like, the answer is because I said so. Ipsy dixit. No one's going to argue. No one's going to argue with you. Just bring the Ipsy Dixit.
Yes.
And now we got to perseverate.
Is because that's exactly what Dr. Welcher is doing. In a 140-slide presentation, it's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Dalbert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the decedent. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, there is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures
so this
to
is
which
not
the
the
employee
expert in
was
this case.
subjected caused
He's
and
quoting
causes
case law
italics in the opinion.
and
Her
what happened in that
suffered
case.
from MCS. This was an error. They went on, quote, because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences.
It does say
because the
expert
judge below did
medical
not conduct
testimony.
a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion. In the concurring opinion of Justice Greeney, he added an important point. I quote, further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science. The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference, but here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So
Dubious is also a great word.
I rehearse
as long as it's not dubious
provisions
food
of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks, and that is another SJC decision.
So he's going through the case law to support his position
all of the cases that I'm
that they
providing in my
need
oral argument
methodology.
are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera.
Same.
Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial.
Right.
And
there
I've
has to
made
be a
this
methodology
argument
to test things
many times
against.
before
Because you can't
about the
just say shit
prejudice
as an expert.
to misread from the pattern of the Commonwealth to provide experts long reports, long CVs, completely silent on tethering the methodology to a study,
based on
etc. And the SJC points out that that information is quote, essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation, and this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment.
I'm going to slow him back down as we're talking about painting the roses red, because we're getting into the territory of throwing an iPhone around. So I'm slowing him down because I'm going to need more information.
What the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of
ARCCA
Ritolo.
does experiments
We basically
too.
cited it for the proposition of qualification.
Experiments can be allowed.
We haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion.
And Alessi had said that this expert, someone painted an arm blue and painted a hand yellow to try to show where I think John O'Keefe's arm could have come in contact or would have come in contact with the SUV. So he's talking about experiments being done by the Commonwealth expert, not the experiments being done by the ARCCA experts, but experiments were done by the ARCCA experts. But for experiments to be done, there has to be methodology to them before they're presented to the jury.
What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed
in this
sufficient
other
education,
case,
training, experience, and familiarity.
He's talking about the other case. So disregard what I said. He's talking about the other case and what was being done in the other case and whether that was sufficient or not. That's why I slowed it back down, so I didn't also lose what he said. So he's talking about the other case law. That's where we're
To
at.
determine forensically
Whether it's an appropriate
when
scientific
and how
test.
the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Ritolo was, listen, this person was a
All
paint
case law.
engineer at his company, and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Ritolo. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation.
Right.
Skipping. The conditions in the
Other case law.
experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started.
Well,
So they immediately
so did
said,
ARCCA, though.
if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Gianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors.
Oh, I wanted to pause, and that didn't work. A number of you asked this in the chat, and it's a great question. Cishia said, ARCCA didn't do their experiment just for the testimony in this case. No, but they did it specifically for the purpose of litigation. So where his argument and the case law here is whether or not this was done specifically for the purpose of litigation, ARCCA does that too. And a lot of you have also distinguished this, which I think is the fair distinguishing factor, is that it is part of ARCCA's regular line of work, and that is the next argument. That's part of ARCCA's regular line of work. So yes, they did it just for litigation, but it is also what they do in the line of work. That's the distinguishing factor. Here, the defense is arguing that this expert did this for the purpose of litigation, and it's not part of their regular course of work. So there's two parts. So that's where we are going with this. So when I said ARCCA also did it for litigation, they did. The distinguishing factor is that it is part of their regular work. They are saying here it's not part of this expert's regular line of work. The expert did something they never regularly do, and that's the problem. Coroner armpits, that's part of their regular line of work. They did it all the time. It doesn't mean it's a proper methodology or experiment. So there's two parts. Hopefully that helps.
It would make little sense to attempt to apply them here.
So that's where the case law is being argued.
The SJC said we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened.
Oh yeah,
And
the
it
court's
then
not
said,
making work for themselves.
relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Gianelli's methodology or experience. Instead, it appears that Gianelli designed these experiments on his own without any guidance. Reading down below, quote, Gianelli's experiments also did not appear to have been performed consistently with basic scientific
I disagree. I think Grim Faded in the chat said, but ARCCA didn't do it for litigation. They did. ARCCA did it for the grand jury for the feds. So that loops into all of this. They did it specifically for the federal grand jury, for court. But it is part of their regular practice. So litigation doesn't have to be just this case. That's how I see it.
We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles because his report in the slide presentation is completely bereft of any citation to
The
basic
defense is going to be
scientific
bereft
principles.
about this as well.
Next,
I'm looking for their
the court
motion so I
said-
can pull it up. So
Giulianelli
That's
did
what I am
not
doing.
repeat or validate any of his 6 experiments is also
I got it in here somewhere.
There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC.
Incredibly
With
recent.
those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January
He's
30,
like the letter.
2025
Could hear Alessi's eye roll.
document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what
Your Honor,
he
I'm not
said
long-winded.
the role of a biomechanical
The expert's just
engineer
bad.
is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria
the
usually
MA said
take
too.
the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that is what
He's like, right.
biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do.
Right.
And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important.
No.
What
Go for it.
biomechanical engineers do
We're here for it.
is they apply Newton's second law of physics, which
Go.
is force net equals mass times acceleration.
We've gotten to Newton.
That's the mathematical formula. Because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should
Don't yell at me, Your Honor. I'm trying to help.
be disallowed from him opining on.
That would be helpful.
Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C.
So a lot of this motion or parts of this motion are impounded as the defense is moving, to keep out parts of the testimony of the Commonwealth's biomechanical engineer. This is a new expert that did not testify in the last trial. So now Alessi's going to list out the things he specifically wants to keep out. So I'm glad we are back at regular speed to go through that.
Improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only
Weighing the
using,
credibility
but he's
of
trying
testimony.
to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record,
God, that got so quiet. Experts are allowed to rely on testimony. That testimony came in last trial. It'll come in here. And he can say, I credited this testimony and relied on it, and say why.
would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
That's true.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is
He can't
an
rely on it,
expert
though.
witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C
Some of this goes to weight.
should be excluded. Now to 2. 2A Romanets.
I think it's fair to distinguish that the expert can say, I chose to rely on this and didn't choose to rely on this, versus I'm making an expert finding that this is what happened. There's a distinction there that's important. TT asked, who are the laptops? That is where the media sits, and that's where they sat during trial. But there's a difference. There's a difference to be split on. I reviewed all of this and used this information to make my opinion versus giving the opinion that a certain fact scenario happened if that fact scenario is contested. So that's the distinction here. But this is going to be left for cross-examination, I think.
3 and 4. Romanet 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer
That's fair.
get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer.
I think that's fair.
And when he set up his own boundaries, he didn't talk that he was going to be looking at.
And again, I think an expert can say no fragments of taillight were found at 1 Meadows Ave, which is different than the taillight was not broken there. And Alessi is going through this with a fine-tooth comb saying the distinction matters. You can't just say the taillight wasn't broken there. That is a contested fact for the jury to decide. You can say pieces of taillight were not found there. Those are different.
At contested evidence, Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet.
I think that's fair.
That's an evidence, collection of evidence,
He's
preservation of
allowed to use
evidence,
that, though.
etc. It's not for a biomechanical engineer.
It's not
Then he
for him to
goes
make an opinion,
on
but he can rely on it.
C. Testimony of Jen McCabe. That's his heading.
Alessi's like, can you believe it? Who's relying on this? Some of this is going to come in. Some of it is going to have to be refined. But I would want to see the report, which we don't have, about whether this is what was relied on or if these are findings. But Alessi said the heading was conclusions. And if the headings are conclusions, an expert can't come in and say, I credit this evidence as credible and this evidence is not credible. They can say what they relied on, but they cannot make a determination. So I understand that there is it is a narrow distinction, but it matters greatly for court. And I saw a great question. Brianna said, never heard of Romanet before. It's a case law. So he's pulling from that, but that's a distinction. And he's picking apart this expert report, saying the expert report is listing these as conclusions, and he can't make a conclusion about credibility of a witness. That's for the jury.
Karen Reed stated to her, et cetera, et cetera. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only
That's an overstep.
trying to credit testimony.
Yeah, that's
we've
an
got
overstep.
now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now,
Experts can rely on
continuing
testimony, but
on
they can't
page 11
credit
at the
it
top,
as true or not.
and this is C Romanet 1.
Oh no, sorry.
42622 Julie McCabe.
Apologies, chat. We're not talking about the case law. He is talking about the little Roman numbers. Apologies. My brain glitched. Sorry, chat. I apologize.
42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses.
It can be relied
Inherently,
upon,
he
but
is
it can't
crediting that testimony
be the
as
opinion.
truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570.
That's the heart of this argument. I'm going to back up. This is the heart of the argument. The heart of the argument, an expert can't come in and say, this testimony is accurate. That's not, ignore it. That's the job of the jury. This is the conclusion that the defense wants to challenge here. That John O'Keefe's arm was injured by a taillight. If the defense can't present the ARCCA experts saying that John O'Keefe's arm was not injured by a car, I don't think the Commonwealth can bring in a different biomechanical engineer to say the arm was injured by a car, no matter what kind of math you apply. So this is, we're getting from the, not the main bit to the main bit.
Alone, a
Whether the car is
biomechanical
biting or not.
engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent?
Not a
They
doctor,
don't
Your Honor.
exist. 4, and that should be stricken and not allowed. 4.
That's the part of the heart
Perhaps
of
the
this.
most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious.
He's
4,
incredulous at
the
this point.
totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, et cetera, of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist, he's not a hydrogeologist, he's not a geologist.
Alessi knows so much shit. Your Honor, he's not a hydrogeologist. What the fuck are we even doing here? It seems that the biomechanical engineer from the Commonwealth wants to give a lot of opinions. They're going to be able to talk about the ground because ARCCA was able to. They're not going to be able to talk about how hard relatively the ground is or is not. But the Commonwealth bringing in some of these witnesses, I think, will open up the door to things ARCCA was restricted about in the first trial because the Commonwealth has a response. I prefer, this is my preference. I prefer if it is within the realm of expertise for the expert, let the experts talk, let the jury decide. Let the experts explain, let the jury decide. But the Commonwealth bringing this in is going to expand, I think, the ARCCA testimony.
He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert.
He's allowed to rely on other expert opinions.
Also, once again, talking about testimony of individual witnesses.
He's allowed to. He can't.
He says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
I don't think that's an
Wouldn't be
opinion.
introducing evidence of frozen ground through Dr. Welch.
I don't think it's an opinion. And Brennan, you didn't answer the fucking question. That wasn't what she asked. He sidesteps everything. This man must be very frustrating to have an argument with because he sidesteps the answer. Alessi is trying to narrow down what opinions this expert can give. Is it within the purview of this expert to give an opinion about this and that? The court is trying to clarify what opinions the Commonwealth is seeking, and he sidesteps it.
Manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
I wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the
Cause of death.
He would not be.
What happened to the volume? Why did everyone start whispering? What the fuck? All right, let me gain this up a little bit. Today, Brennan sounds deflated.
Is there other parts of the
Cause of death.
He would not be offering the cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
But if he put them in his report as conclusions, you can understand where opposing counsel is like, but if these are all his conclusions, what are we doing?
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one.
He's like, thanks for stepping in, Your Honor, but no, you're not helping.
Thank you. So 4A,
Let me handle it.
he says and this is what he means.
Earlier on, there was a great question in the chat about whether I was sometimes as loquacious in court as today Brennan has been or Alessi has been. And I said I was going to hold on to it later. I'm going to elucidate that a little bit at the moment, because what I found for me as an attorney and what I found with the attorneys that I knew well and watched before different judges, the more the attorney trusts the judge to make a thorough and reasoned consideration, the less they talk. This is my experience. The less the attorney trusts the judge to understand or to make the right call, the more they will talk. And I think this is true for a lot of humans in life. The more you feel like you're not being understood, there is greater risk of over-explaining yourself to the nth degree. I think that there is frustration here, and we see this with the defense, of not relying or trusting this judge. When you feel like the judge has got it, you see the attorneys fight less. We saw this really illuminated in New Mexico, with the more Judge Summer allowed the attorneys to fight with each other, the more the attorneys just started fighting with each other. So if it seems that a judge will credit the attorney who has the last word, the attorneys will keep speaking over each other to try to have the last word. When the judge is a little bit more stern with everybody and keeps a level playing field, all the parties relax and trust the judge. So you need a judge who is, for lack of better explanation, kind of the leader of the pack in the courtroom. Because then if everybody trusts the judge, it brings everything down a notch. They make their arguments, they move on. We saw this in the pro per cases aren't a good example, but we saw this with Judge A. When the attorneys trusted Judge A, they just said, my side's this, my side's that, that's the end. But in this case, not as badly as we saw in New Mexico, but you see the attorneys continuing to talk because they're trying to make sure they're end routing what they think the judge might not get. And that's where we see a lot of explaining in this court versus other judges. And you'll see other judges say, I get that point. Can we move on? So I think that's why we're seeing more explanation, because there is not trust there, which I understand. Oh, my colon did it. Smurfana said judge versus the new Koberger judge. This is the perfect example, Smurfana. With the Koberger case in front of Judge, the attorneys were constantly talking over one another and just continuing to go. In front of Judge H, they make their statements and they sit down. That is a perfect example, because same attorneys, two judges. I couldn't think of a better example. Thank you. Exactly that. All right, let's continue.
By totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure Your Honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight, and that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect.
Brennan is saying we're not going to be bringing in the hardness of the ground. I think his mic is off. We're not going to be bringing in the hardness of the ground through this expert, but we will be bringing in air temperature because air temperature goes to the relative force it would take to shatter a taillight in different conditions. Because one of the arguments from the defense, and I think that we'll see from other experts, is if John O'Keefe's elbow or arm hit Karen Reed's polycarbonate taillight hard enough to shatter it into 40 plus pieces, why is the taillight shattered and not also the victim's arm and or elbow? So I think the mic's off, so I'm going to gain this up a little bit.
We can rely on that to talk about how that might affect the taillight. But the frozen ground, we agree, that would not come in through Dr. Welcher.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
Because it's going to come up with
E. Hat line and fracture location.
air temperatures. Probably, if the Commonwealth brings it in, ARCCA will be allowed to talk about it too.
Consistent with fall and posterior head strike. Extraordinary.
Why is it extraordinary?
Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head.
I forgot to feed my Snorlax and Pokemon.
And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue.
Yes.
Now with regard to F. This is the wayward,
Also, an assault can
undocumented
cause a fall,
experiment
so
that Dr. Welcher conducted.
carry on my wayward experiment. I want to hear all about it. I'm not in trial habit
F,
yet, so
Romanet 2 should
my habits
be
are not great.
excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads G's of approximately et cetera,
Drop test with a head is what he just said.
That experiment I've covered in what the case law requires for him to show. There is zero support
Zero.
for
Zero.
this experiment.
Zero. None.
I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area.
So again,
but
the paint
you've got to
experiment
show
from the
all
other
of these
case.
things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher.
Is extant.
His experiment must be excluded
His vocabulary delights
if
me.
Rentola is to have any meaning in Massachusetts jurisprudence. G. Julie, Nagel, and Ford occupants.
These are a lot
Again.
of conclusions.
What does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128 and early morning of 129. H. Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet, he's proposing to testify and state that? What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H. Romanet I. So, with regard
Some
to
of this should not be in the conclusions
Dr.
section.
Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds, based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury, and the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know,
You're going to
is he
spiral me
really
into
directly
singing
or explicitly
Carry On My
doing
Wayward
it?
Son, counsel.
The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintolo talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient.
Whoop, there it is.
And based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it.
Oh, boy.
And the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to ARCCA's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to introduce it.
Do you intend to use all 140 or however many?
No,
He
that
said
is-
no.
We were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides. is
Okay, but
the,
what are you producing? What are you
cameras showing the
presenting
different, data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welch's arm, and also we would want to show the ways, locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
And
Right, so this
yes,
will have to be provided to you prior to it's done.
Thank you.
He's right.
And do we have a date so we can adequately?
And that puts the defense in a tough position. When the Commonwealth just like word vomits everything, how do you prepare? It's like, are you going to show all of it, none of it? You need to show me what you're going to show so that we can then work on it. And the Commonwealth's like, oh no, we're going to pare all this down. And he's like, okay, when? Because the deadlines are passed for this to be done. When?
Adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I could have them by Monday.
Okay.
And Your Honor, if we have an issue, still, can we submit
Yeah.
something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basis.
Sure.
Right, new
So
information
you'll
might
get
bring
what
new
you're entitled
objections.
to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond, and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher
And the court's going
is,
to wait
in
until
my
the Commonwealth
experience,
streamlines this.
unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court as the gatekeeper a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with
Your Honor,
regard
who
to
are
that
these experts
tethering.
anyway?
And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion, I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and
Alessi's still talking.
we
Can
would
just
like to avoid an evidentiary hearing
Go back.
because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Your Honor, if
Brennan?
he doesn't do his assignment, I can't do mine. The assignment was Haiti, and he's talking about some garden party. Your Honor, what are we even doing? And then the Commonwealth is like,
Disappointed that Mr.
and then the Commonwealth is like, yeah, we will narrow it down. So we've gone full clueless with that last argument. Amanda in the chat said, it was his 50th birthday. Okay, Brennan's going to get annoyed. I can already hear it.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a case study in that is the
What are you doing? I'm not going to digress the way he has. Of everyone on the defense team who gets hyperbolic, Alessi and Attorney Little are at the bottom of the list. Jackson, Yannetti, Alessi, Little. What are we doing, Brennan? I am so disappointed that he would think, what? Lord, Brennan, you are losing me. Good Lord.
oh, please.
I'm going to just let him go again because the audacity.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a
I
case
bet you
study in
will.
that is the ARCCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data.
I mean, that
anything
intro was
that
a
he considered,
digression.
Even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire
Big,
file
huge,
to the
the
defense.
best production ever, Your
All
Honor.
of the raw material.
Their production
all
sucks.
of the
Our
studies,
production is the best.
All of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher,
It sounds
cannot
like he
come
put
in and
a
talk about the opinions
bunch
or
of
testimony
shit
of witnesses
in his
as it relates
conclusion
to their
section, though.
statements. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. The testimony of Jen McCabe is for Jen McCabe and the jury. He will not be
If he put it
offering
in his
testimony of Jen
conclusion
McCabe or
section,
offering anything
though,
that relates to it.
one can
Similarly,
understand the issue.
2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather, if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground.
Okay.
Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses.
It
Not
is.
for Mr. Welcher.
Right, but then he shouldn't have put it in the conclusion
so-
section of his report.
The
So it's confusing.
basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive.
I mean, if he's a
litigation.
biomechanical engineer, he
They
probably
weren't tethered
has.
to a specific study, and the methodology
Depending on
for
what they
each
are.
one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCCA experts, because when I'm looking at the ARCCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the
Oh, hey,
ARCCA.
sound. Welcome back.
report, you have one witness who decided to build a potato cannon for no reason that we know of.
It was not a potato cannon. It shot rocks glasses. But we knew this is where we were going to get to. And if the defense is arguing that it is not sufficient when the Commonwealth does it, the Commonwealth is going to come back in and say, okay, but it's the same. And if they are the same, the court's going to let both experts in. That's the result. So if the experiments by two different biomechanical engineers are done appropriately, then it's for the battle of the experts. But we knew it was going to come up, right?
No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand.
I mean, 10 out of 10, it was pretty awesome. That was their testimony.
That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon.
His argument might
That
be
wasn't
wrong here.
repeated or validated. There was no specific.
I have fucked it with the volume. Give me 1 second. This is an Emily issue. Let me turn this back down so I don't offend anyone's ears. Give me 1 second.
literature that was referred to
All right.
in that
There we go.
report. And yet, not only were they allowed to offer this evidence,
The volume.
it wasn't
jumped.
inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it.
I definitely want video of the cannon. I definitely want video of the cannon. I'm not mad at this argument either. Okay. Fine. And this is not an unfair ask. If the Commonwealth's biomechanical engineer performed experiments and those were video recorded and documented, it is fair to ask, how was this experiment conducted? What did it look like? What were the results? That's fair. So this is where that discovery fight comes in. And that's a fair ask for the Commonwealth to say, we should have the same information. So bring the cannon. I'm here for it. I'm not mad about it. But he has valid points here Where they get lost for me is when he starts at the beginning with, I won't digress the way he does. The grandstanding puts me off so much. Start with the legal arguments. There are defense attorneys who do this too, but it just, ugh. It is off-putting at times. Sometimes it's funny. Sometimes it's off-putting.
Or maybe some details on how it actually operated.
This
See, these
is
are
fair.
the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs. Quite unlike ARCCA, where it is just simply a conclusion based on just trust me. And so when you look...
You were so close to trust me, bro. Brennan, you were so close to trust me, bro. So Alessi is saying that the Commonwealth's expert is based on Ipsy Dixit, which is because I said so, or I said so, or he said. And the Commonwealth's response is, I know you are, but what am I? Your experts are based on trust me, bro. I agree that there are discovery issues with the ARCCA experts. I don't know what the solution is for the discovery experts or the discovery issues with ARCCA because of the conflated circumstance with the federal government. That's different than the discovery issues the Commonwealth has had because there are intervening third parties. Wow, today is spicy.
At the production by Dr. Welcher,
Yeah, bring it all
it
in.
is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science, and it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts.
Then ARCCA
Now, this
should
is
too.
the same thing that ARCCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alessi is Mr. Welcher's drop test. If you look at the ARCCA report on page 10, they do the very same thing. Except that they
Really?
don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different.
If that's true,
And so-
the court has both those reports, it's going to come in, and it's disingenuous of the defense. If ARCCA's doing the exact same drop tests, it's disingenuous. But I don't have the reports to compare. The court will, but it would be disingenuous to argue these drop tests that are done the same way are one is fine and one is not. It's fair, but you also need the rest of the discovery with ARCCA, and I get it.
So there are no medical diagnoses by Dr. Welcher. These are his opinions based on his study of the evidence, and he goes
But are they
to
talking
the
about
extent
mechanism
of
of
actually
injury?
demonstrating those different
they?
assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alessi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they're given. They both have a different opinion about the taillight
That's
causing
what
the injury to
experts are
O'Keefe's
for.
arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCCA, it must be acceptable for Dr. Welcher.
I agree. It should be the same for all sides.
Dr.
I don't
Welcher
disagree.
actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The tech stream data is critical in this case because it shows time and place with the new information that we have.
Well, then the
So we
experts
know
can
from the
fight.
Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until.
So it sounds like they have been able to successfully access additional digital data from the Lexus because they now also have Waze data that they did not have, and other data that they did not have before, because the other experts were like, we don't know what to do with this. So it sounds like the new experts have been able to get additional information. It's for the defense to share that with ARCCA or not share that with ARCCA, but that's what the battle of the experts is for. Oh, our expert considered this. Your expert didn't consider that. The fact that they've done additional information or gotten additional information here is not surprising to me based on what we've seen the Commonwealth say earlier on. But doesn't that go to the defense side of this case? Is it the investigation that you are still having new stuff come in 2025 as they're getting ready for a second trial? David JG said last time they said they said no more info from the car. Yeah, they said they couldn't get anything else. But I think that was a skill issue, not that it didn't exist. So we
have all that evidence, and as a
I say let the experts fight. Bring it all in.
engineer, he can consider all of that technical
bring it all
data,
in.
which will be
Let everybody
introduced
bring-
through other witnesses at trial before he testifies.
Let everybody bring it
And
in.
it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes,
John O'Keefe's phone connected to the Bluetooth in the car is going to be very interesting to me. It's going to be very interesting to me.
we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides.
Cell
He should
phone
be able to
battery temperature
consider
will be
these
interesting
things in
too.
his study. This is what he does.
That'll be interesting.
The demonstration at Meadowbrook, John O'Keefe's house, is depicted
Meadowbrook?
by measurements, which has been
Meadows Avenue, not Meadowbrook, Meadows Avenue. Look, bring it all in. Let the experts explain it the way they're going to explain it. Bring it in. Let the jury see it. The jury gets to decide.
provided, science and data, by the Ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation he actually shows not only the nudging and the car leaving through the Ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion.
wet
This
was
isn't
the
witness
snow?
testimony. And the jury should see that very evidence. It'll be admissible not only through
Snow
him,
can
but through
shift
independent
because
witnesses.
of nudging, but I want to hear it. I want to hear all of it. Bring it in.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCCA employs. They just didn't do this. And so that's not what.
Well, then it should expand what the ARCCA employees testify to as well. Let the experts all testify and let the jury decide.
This testimony, that's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that
The jury
ARCCA
should get to hear
proposes
it
in their
all.
report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements, and we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCCA information. It does concern me delaying that information because, as Attorney Alessi eloquently said, you need time to prepare. We know he's a very prepared attorney.
He is. Agreed.
We'd like to prepare as well, and if we wait to
I
get
said the
records and
Commonwealth
information and know
would be unhappy
who
with
wrote
that.
what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that
bump the
questioning
voir
well
dire
before their
forward.
testimony.
Right.
But we will meet our commitment and provide those slides on Monday.
They can take it. They can take a
Mr. Alessi,
Friday.
again, you've already said you agree to talk to Mr. Brown.
They can take a Friday during jury selection and have those witnesses come in. The difference between what the Commonwealth turns over and what the defense turns over is that the FBI and the U.S. Attorney's Office are a factor here, and that's difficult. But we are seeing how many new experts the Commonwealth is bringing in. This is going to be a very different case. JF King asked in the chat, wasn't all this available during round one? No, it wasn't. The Commonwealth has hired new experts. The Commonwealth has done additional scanning, additional testing of the car. Not all of this was available during trial one. This is going to be, expert-wise, a very different trial. And I think it'll be interesting to see what more the ARCCA experts can disclose. Again, let the jury decide. That's what experts are for.
Brennan, about the reciprocal discovery. Okay. Sure.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data.
He did
Quote,
say that. Oh, my chat just crashed.
someone alleging that it's science and data doesn't even begin to approach that the methodology is established in
It
the
doesn't
literature
make it
or
so,
satisfies
Your Honor.
the Abt-Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that
Faith asked in the chat, so new evidence is still coming in. There is new information that is still coming in. The discovery should be done, but there is some discovery still outstanding particularly from the ARCCA experts. So there's still going to be stuff coming in, but the Commonwealth's discovery should be done. We'll hear about it if it's not.
tethering doesn't exist, then the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCCA report does not set forth the methodology.
Does it?
There are 14 footnotes in the ARCCA report. I just looked at them again.
It's an impressive amount of footnotes.
Footnotes 1, 2, and 3 tether the methodology of the ARCCA experts to the literature. The methodology is documented. I do not understand how an attorney...
Do not fuck with the ARCCA experts. Look at how mad Alessi is. Alessi's like, do not mess with the crash daddies because I will bring in footnotes and fuck you up. I don't think I've ever seen Alessi this pissed. He's like, do not get in court and tell the court that they're the same. Are you fucking joking me? I don't think I've ever seen him that mad. Ever. Oh, Alessi is pissed today. Pissed off Alessi is kind of funny. He's so mad. All right, I'm going to let him go. He's like, do not compare the two. You fucking joking me?
Tether the methodology of the ARCCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it.
The fact that he has reined in a statement along the lines of, once again, Attorney Brennan has gotten up here and misrepresented to the court what the facts are. He might get back to it, but he's pissed. He's restrained, but he's pissed. Huh. If it's in the report, you can't represent that it's not in the report. Oh, Alessi's done being fucked with. He's like, I am fucking done. When you make Alessi mad, you have fucked up.
On a key issue that is...
I don't want to wreck the flow of Alessi hissing at Brennan.
I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it.
Wow.
On a key issue that is disputed. Attorney Brennan also falsely stated that ARCCA did exactly what Dr. Welcher did with regard to medicine and medical issues.
With the drug
test. That is completely false. ARCCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then...
Everybody's like, oh shit. The whole courtroom is like, Alessi's the calm one. Like, Alessi's the calm one. Your Honor, they did math. They're engineers. Physics.
And so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then...
I'm sorry, the weight of the human head is what? I'm going to keep going.
Take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis.
Engineer shit.
ARCCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, There is no equivalency
He woke everybody up
between
before
what
lunch.
ARCCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, "This is what he does," referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions,
he's so mad
which
his
the court can
ears
take
are
judicial
bright
notice
red.
of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation.
Alessi will not be out-nerded, and he will not stand for Brennan misrepresenting shit. He is so done.
In the beginning, I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question's not what did he do, but is it accepted in the medical literature?
Okay, Alessi, I'm sorry to interrupt, but this kind of feels like when your favorite teacher all of a sudden is done and like goes off, and you're all just like, oh, fuck. Y'all have pissed off the nice one. Y'all have pissed off the nice one, the calm one, and you all fucked up. Damn. Everybody go run laps. Y'all are in trouble. He is so mad. It's wild to see. I'm just like, shit. What have you done? Also, I'm living. Alessi is like, I have been deferential. I have been patient. I have been thorough. And now I am done. Do not take my politeness for meekness, because I am about to literally breathe fire in this courtroom. And everybody's like, oh shit, it got hot before lunch.
So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature.
Where's the
He finally
methodology, Your Honor?
concluded by saying, this is within the bailiwick of Dr. Welcher.
He did say that.
I don't know what this is, but bailiwick is
Alessi, I know. This is the Ipsy Dixit. We found it.
a tautology. It doesn't say
know what a
anything
bailiwick is, though.
about whether what he did is rooted in
I might need a Bailey coffee.
the
at lunch.
literature or that it satisfies the Dalbert factors. So, in conclusion, Your Honor,
What the fuck?
I go back to Rintala, I go back to Meeks, I go back to
The
the
footnotes.
case of Caravan. The Commonwealth has
sky's
not
getting
today,
cloudy.
not before, this is their 4th time,
Not today, Judge.
has not satisfied what the Supreme Judicial Court requires in these instances.
Emily, don't make jokes about what the
And
Commonwealth has or has not satisfied. Do not.
What it has come down to is the defendants, which stands in a different position. This equivalency between ARCCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden.
point.
They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Do we have to? Yes, we do. All right.
Regrettably, I know Attorney Alessi has decided to join the fray of disparagement. Now, he has said 3 times.
You shook the hornet's nest, Brennan. Your Honor, regrettably, Attorney Alessi has decided to join the fray. Sir, what? I'm waiting for Alessi to stand up and turn around and go, it's Alessi. It's Alessi. That's all. Sir, just because you're not loud, Brennan, doesn't mean you're not being incredibly dramatic. Keeping the same tone, we still hear the words, sir. Oh my God. Oh my God. The drama of this prosecutor.
Regrettably, I know Attorney Alessi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied.
Instead of talking about the media, can you tell me whether or not the reports are connected? Because you're just sidestepping the points that he made to say he's attacking me. You've just gone like, whoop, he's attacking me because media. Can you address the points though? You're not addressing the points. And if you can't address the points, you address the speaker. And that's where we go every single time with Brennan. If you can't address the arguments, attack the speaker every single time. Okay, I'm going to try not to pause anymore.
Now,
I don't know if I'll
he
be
has
able
said
to.
3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times.
You talking about yourself?
We found
in
some of
third
those
person?
transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alessi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute,
Pissing match?
but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alessi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report.
But are they
It's
tied?
not footnoted like ARCCA, it's at the end of the report. It's all there.
But if it's not footnoted, which aspect goes to which resource? So if it's not this thing comes from this study, then what is the source if you don't footnote it? All of this shit could go to all of that shit? And if they're an expert, are resources and science law nerds, are resources and references going to be the same thing in a report? And do they tether back together? Also, Brennan, you have had to issue corrections on the record numerous times because you have made numerous misrepresentations to the court about statements made to the media that were in fact made in court. So if you want to have a pissing contest, I don't think it's going to go well. But he's leaning into the fact that the court has already been pissed at the defense about this week. And he's not gotten yelled at about it this week. Oh, boy. He very confidently said, all of this was given to me by the feds. And then after the court took a break, and at the very, very end, after the court lost their mind about it, came in and said, those came from the defense. Okay.
All right. Thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection
Okay.
to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations and
All
chalks
right.
prior to using?
No objection.
Okay, thank you.
Alessi's like,
583.
he's so mad. He looks so mad.
Is
I don't
there
think
an
he joined the fray. I think
objection to the
Alessi is
Commonwealth's motion
actually
limine to allow
at his
the
limit.
expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. All right, is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it unless, you tell me what
No,
Your Honor.
let's
Alessi's
see what
like,
we can get before
no,
the
the fuck
luncheon
we're
break.
not.
The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
This is we have moved on to, they tabled one motion for later, and now we're moving on to the Commonwealth's motion to admit the victim's out-of-court statements regarding state of mind. So that's what we are getting into now. The defense has objections to that. Some of that can come in. It's going to be interesting to see where which statements he is seeking to introduce, and if we get into it now.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case.
When are the statements from, though?
In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant.
I mean, I don't think that's in controversy.
We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing.
Oh, well, now we can hear you.
The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them.
What
And
is
it
the
is clear,
timing?
based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day
There we go.
of this incident,
All right, so what's the time frame? It's so over the course of the day.
Your Honor, you and I are on the same
I
page
realize
with
that
this.
the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
as
this?
far as his messages, I will
Or
look.
the statements, or the evidence that you're trying to put in under this doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And would introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And
You
there would be
didn't answer
nothing
that.
different from the last trial, other than the fact that we
Time.
are not going to pursue the Aruba information. So
I
it
think
is
that's smart.
actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief, given that explanation by Mr. Brennan, than I intended. or anticipated.
So Brennan said we're seeking to introduce what we introduced at the last trial, nothing new and different. The court said, what is the time frame? He started to say day of, but then he said these are the same text messages that we put in the last trial. So those are going to come in, which is why you see Jackson saying, now that we know, and this is the problem with Brennan, he states things kind of broadly. And so the defense is like, well, depending on what you're seeking, we have different objections. And then when Brennan gets up and says, oh, we're just looking for the text from the last trial, the defense is like, oh, well, if that's what you're looking for, why are we having this conversation that's sorted? And this has been an ongoing situation back and forth where once Brennan explains in court what he's looking for, the defense tends to go, oh, that makes sense. Let's narrow that down. Which is why you just put it in the motions.
I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Ms. Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent with...
That's what we were talking about, the bins, calls, those points
correct.
That need to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea... There is no evidence to support that last point, that this type of information...
Without Brennan talking about what statements he's looking to bring in, it's really hard to parse. But there's a difference between statements made to friends and statements made directly to Karen Reed, and that's where we're parsing this about what statements of John O'Keefe go to state of mind with regard to the relationship, and whether or not that falls under the case law that the court is citing. So that.
Let's say, for instance, it's information that he wanted to bring.
On this one, though, chat, she interrupted the Commonwealth as well. She interrupted the Commonwealth and the defense both on this point and tried to redirect Brennan.
Break up with her. Or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a
I fed my 17-year-old donuts this morning. Just saying.
What was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that.
That's for argument.
The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statements.
This argument might be where some of Karen Reed's out-of-court statements come back to bite her, because in the Discovery docuseries that just got released, Karen Reed talks about how upset she was with John O'Keefe the night before and that day. And then she shows up at the bar and they're getting along. That doesn't mean that there hadn't been fighting that day. And she said that she was pissed. So those statements from that last interview might change the outcome of this argument in court. I'm wondering if Brennan will bring it up in the rebuttal.
That went uncontested, that they were affectionate, they were happy together. They were described by basically everyone
They were
on the
but what happened on the
Albert
phone and what
side, the
happens in
McCabe
public
side,
is
as
different.
well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening, and they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. You can couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both CF.
As I remember it from the first trial, you guys remind me, but as I remember it from the first trial, there were texts between the two showing, and it's, again, I agree, it's a different analysis, but there were texts between Reed and O'Keefe showing that the relationship was not going well. And then there were all those fucking awkward, ridiculous texts between Reed and Higgins showing that she was exploring what other options may be. So whether or not the texts between the two come in, and I think that they do, is different than whether third parties can say, yes, he was also telling me that they were going to break up. But their texts between the two show that that was going on.
F. McCarthy that night, as well as at the waterfall that night, but showed the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe
I disagree with his argument on this. Based on the evidence we've seen in the last trial, I just
happy in the relationship that he might.
I'm just trying to move the things. I don't find these arguments helpful based on the state of the evidence, but we'll see. I mean, they were clearly going back and forth in this relationship, and we see that in the Higgins texts. I think a lot of this is going to come in. I wish he would narrow it down for the third parties and separate out the text between the two of them.
Want to break up or in the relationship, that would have been a catalyst for murder, and that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job.
I don't disagree with that.
Had her own house. She was not dependent upon John for anything, not from.
Yeah, they're fighting back and forth. The Commonwealth reaching that fighting back and forth is is grounds for homicide, I do think is a reach.
Money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth...
I mean, I think the best evidence for me of the fighting not being motive for homicide, there's a lot of other stuff in this case, but is the voicemails left. The voicemails left after give a lot of context. So the reaching that those fights, and again, people fighting can trigger homicides. It happens. But in this case, in these facts, in these text messages, is that what happened here? And I think the voicemails after that are going to come in give more context to it, but I don't think that keeps the text messages out. I think you need the text messages and the videos at the bar and the voicemails to give full context.
Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her,
Or
and
go
they
back
both
to
go
her house
on their own way.
and just be like, I'm going back to my
It's
house. I'll see you in
absurd.
a few days.
And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends,
I think that's
in a
an
good
overreach
mood,
as well.
and happy with one another.
I think they were fighting and they went out with the friends and were like, can we just have a nice night? I think they were in the process of fighting and were like, can we just have a nice night? And then at the end of the night, she's leaving voicemails like, apparently fucking not. So
We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined
before
quote
Brennan gets back up,
that I think is illustrative.
is Brennan going to bring up what Karen Reed said in the latest docuseries about her being pissed at John O'Keefe before they got together to try to have some fun for the night? Is he going to bring it up?
For our purposes, Your Honor, quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character,
Your Honor,
make her look
it's
bad
not
and say
state
that
of
she was
mind.
either a bad girlfriend
It's talking
or
shit.
that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
Quick follow-up. She said quick.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43,
I don't
line
disagree
1,
that there's
she was
evidence
asked,
that they
would
were
you say that
unhappy
you were
together?
angry with John that night? Her answer was yes.
Not the latest docuseries, but he's bringing up the 2020 episode, which I don't even remember the title of, but bringing up the 2020 episode that they have a transcript of. So if any of you are asking, is the Commonwealth going to seek to bring in Karen Reed's media statements? The answer is yes. And they can, whether or not she testifies. We talked a lot about that yesterday. But yeah, they are.
At the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by
They're going to use her
Ms.
words.
Voss on June 20th, 2023, about that night, or the day before, and she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep.
Well, that's after. The timing on that is a little
Now,
sussy,
in addition
Brennan.
to her anger,
I think it's real fucking clear from the record that from the time Karen Reed got to 34 Fairview, no, not from the time she got to 34 Fairview, at some point after she got to 34 Fairview, to the time she fell asleep, she was fucking pissed. We've heard the voicemails. That's true. But that is different. And again, sidestepping the question of victim's state of mind. But yeah, the evidence shows that she was pissed from sometime when she got to 34 Fairview Ford. The question is, was she pissed before that? And the motion is about the victim's state of mind. So the victim's state of mind before they got to CF McCarthy's is what we're talking about.
specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses
I'm surprised you didn't bring up the latest
the
one.
fact that she
'Cause that was before.
hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision.
Can we
And
talk
so
about the
we
victim's
have,
state of mind?
Statements from the defendant herself that show
Grabbing my evidence
the
book.
discord in the relationship, the anger, being pissed, the motive.
BRB.
Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so this should be admissible. It's all supportive of each other.
You've said literally nothing about the
If I could
victim's.
Just correct the record very quickly.
You've said nothing about the victim's state of mind in that. You said nothing about the victim's state of mind in that, though. The defendant's state of mind is a whole different thing.
If anything Mr. Brennan just said was true, he might have an argument.
Okay. Your Honor. Your Honor. Your Honor. He's talking about different time periods. He made a motion about the victim's state of mind and then sidetracked himself. And Jackson can't button his jacket fast enough.
very quickly. If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I've read the I wasn't there. I've read the transcripts." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done.
Oh, shit.
This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Kerry Roberts get together, and as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being
So
about
not after
some
he's
other
found.
woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning,
As I remember the testimony, chat, you might remember better than I do. As I remember the testimony about the Bella child, all roads lead back to Twilight today. As I remember the testimony regarding the Bella child's mother, Jen McCabe was speculating that maybe in giving directions to Karen Reed or John O'Keefe, that maybe Karen remembered that the Bella child lived nearby or something. Like, this came up with Jen McCabe being like, maybe it was this. And then Jen was talking about it with Karen, but I don't remember Jen McCabe testifying that she brought it up when giving directions over the phone in the car, that it was later. So I don't think that she had that conversation with Karen. Travis, Bri, is that you? Somebody was walking into the office.
Yeah, it's me.
Okay. I don't think it was like when Jen McCabe was on the phone, on speakerphone, saying, oh, it's by, like, you know, the Bella child's house or mother's house or whatever. That's how I remember it. I don't remember it being over speakerphone before they got to 34 Fairview. So we'll see how this gets corrected.
Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car.
In the last docuseries, though, Jackson, and accurate on this, but in the last docuseries that Brennan hasn't brought up, she said she was pissed because they were arguing the day before about whether or not she spoiled the kids, and she thought it was bullshit that that's what they were arguing about. And so she went back to her home in Mansfield because she was pissed the day before and wasn't going to, or earlier that day, and wasn't going to go back to the house, but it was going to snow. And so her dad told her to stay the night at home. And she said, no, we always have fun on the weekends. I'm going to go back because we always have fun on the weekends. It's going to snow. I'm going to go back and go out. And so even though she was mad earlier in the day and the day before and had gone to work from home to give a little space, she had obviously gotten to the point where she's like, I'm not so mad. I don't want to see you. So let's have fun. It'll blow over. That's how I interpret that. But she gave those statements about earlier. But yes, I think the Gretchen Voss statement is after.
After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can.
Hi,
No
George.
controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up
But earlier in the
missing
day-
and she went home. Before he ended up walking out of the car, going toward the house,
But
and
earlier
she
in the
ended up
day-
leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning dealing with,
Fair.
did you feed the kids donuts?
Fair.
Yeah, I did. You know I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough
And that's
to enrage
consistent
anybody.
with what
It's
she
ridiculous.
said.
And the evidence that it
That's what
didn't
she said in
enrage
the last
anybody
interview too.
is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish
gotten back to victim
that
state of
this
mind?
was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right.
Oh, shit.
I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22.
Well, I'm ready to hear this too.
Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and
That, remember, he has the entire Gretchen Voss interview. But didn't Brennan say that that came in evidence? Because that did not come in evidence in the first trial. So wasn't he talking about what came in at trial? Because that didn't come in at trial. But if Karen Reed said that in her interview with Gretchen Voss, because he's got all the audio of it, then that's, well, bing. But what was he talking about? I'm so confused. All right. I read the transcript because the court has the transcript too. Let's hear it.
the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts.
He's just going to keep
Page 88,
lobbing
line 22.
insults.
Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right. So we're going to break.
We're going to keep fighting about the
We've got
Bella
a lot of
Child's
ground to
house.
still cover.
The
I
court's like,
suggest that we take the personal attacks
chisme.
completely out of this. Hold on. Both sides.
yeah, take a look at Brennan. Mr. Jackson, you said we need to bring down the drama. Can we all bring down the drama? She needs to look at Brennan and say, everyone needs to bring it down.
Not my words.
All right. So we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on. Both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods,
Hyperbole.
all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2 o'clock.
Your Honor, if I could say one more thing.
He's like, we need to talk about the Bella Child's mother again.
As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
The court's like, The judge is like, get me the fuck out of here. Can we just bring it down? Oh, everybody needs lunch. Everybody needs lunch, myself included. So the court is taking an hour-long lunch break. We are going to be able to zoom through most of that, but I can't zoom through all of it because I need to also go get some food because I'm going to just eat while they get back on the record and take a restroom break. So I am going to take 10 minutes. We're going to take a quick court break and then we'll zoom and catch back up. They've had nary a sidebar today. So Law Nerds, it's time to refill the water. We have gone through this. This is why, Emily, why do you need to go to the bathroom desperately? This, and we finished this before we started stream. So I need to take a quick break, refill the hydration, grab a snack. I suggest you do too. Get the Law Nerd app. I will also ping you in the Law Nerd app when I'm back. It is my intention to take 10 minutes. It's, it's almost 1:35, so 1:45 Central Standard Time is when I intend to be back. So everyone grab a snacky, grab something to drink. Let's get a refill. It's going to be a long day. I thought today might be a short day. Apparently not. We'll zoom through the lunch break and get back into live court in 10-ish minutes. So let us go. Law Nerds, we're going to put on the breaky break music. Don't forget to download the Law Nerd app, and we will see you back here at 1:45. And if you haven't downloaded Midas Merge, our sponsor for today's stream, you can do that over the break too. You can. So Law Nerd app at lawnerdapp.com. Go check out our sponsor. Today is going to be a full court day, but we will get through it. For all of you asking if I will cover the hearing from this morning, if we do not get to it today, we will get to it at some point. It's a fairly short hearing, but I don't know if we will have time to get to it today. So let us head to break. Law Nerds, I will see you in a minute. Take care. Get some food. Get some hydration. We're like at the BRB stage. So BRB, I'll put music on in just a sec. Hello, law nerds. The stand desk is standing. We needed to move a little bit. It's been a busy court day. Oh, this chair is just, well, it's going to be in frame. Can we kick it out of the way? Maybe. We're not that flexible. It's going to have to live there. I thought I had gotten it all the way out of frame. I had not, but that's okay. We're going back to court and it's all going to be fine because streaming is dynamic. Hopefully you grabbed some hydration. I know I did. We have lots of motions left to get to. If you are just joining us for court today, well, I had anticipated today might be a shorter day, but alas, what the court said about the continuance or the delay in the trial is that with the defense and Commonwealth asking for April 28th, the court is inclined to start picking the jury, but not swear them in so that jeopardy does not attach, and take their time picking the jury, but maybe delay the start of opening statements and evidence until the end of the month of April. So we might have some gaps in when this trial starts. It's a reasonable accommodation. The court said it would take about 10 weeks to get another jury veneer qualified to bring in to start doing jury selection. And with that amount of time spent, if you already have a veneer, you definitely don't want to burn it. So the court is trying to accommodate both, giving more time and allowing for this veneer or panel of jurors that have already been summoned to come in and do jury selection. The court already anticipates jury selection in this case will probably take 2 or 3 weeks. So it will be about 2 or 3 weeks. So I think we'll see evidence starting at the very end of the month. Are we ready to get back to court? Let's get back to court. Let's get back to court. I think so too. Let's go ahead and add this to stage. It's going to be spicy, I imagine, after court because, well, after lunch, because now everybody's fed. And it was spicy before lunch. So after lunch, I imagine it's going to be more of the same. And we left off with Alan Jackson being like, but wait, Your Honor, one more thing. And the court being like, I'm not thinking about any of you for the next hour. 10 out of 10, the judge is going back to chambers to play Midas merge. Emily, are you completely speculating on that? I am, but it's probably true. Let's go back to court, shall we? We shall. Court resume. Oh, I told you to resume. Why are you frozen? Freezing
Sometime talking.
There we go. Let's unfreeze, shall we? Oh, it's
And
the
I think we
feed.
can do it.
The feed was frozen, so I have no idea what the court was saying before the feed froze. Let me see if I can back it up just a little bit and see if we can catch what the court is saying. Hello, OnlyFan. Before the feed freezes a little bit. So, optimistically, maybe, hopefully, I guess we'll see. Fingers crossed. We'll find out. Did you all have a good lunch? What did you guys get for lunch? What did you get for lunch? No, that feed is frozen.
And I think we can do it.
Right.
We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side
Eastern
2
time.
minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you
I love seeing what you guys
worked
are
out
getting
a
for lunch, depending on where you are in the world or breakfast or
You
dinner.
asked us to, we haven't
All
spoken.
right, so today's the final trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
And Your Honor, if I
The court, have you provided these? Brennan, no. The court, okay, well, today's the day to have them. We are seeing the court get more and more and more annoyed, and she brought this up on Tuesday with Brennan. She told him on Tuesday. Could
I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
Let me take you 30 seconds. I want the court to be super clear about this one point.
Okay.
What Mr. Brennan referenced.
Remember what I said about trust? 30 seconds.
Be super clear about this one point. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John, and talked about Ashley's home or Ashley's house, that she was Jennifer McCabe, on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I
that
understand what your point is in making
there
it.
was no evidence. No evidence.
Karen
on
Reed
the
didn't
night.
hear it.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure
all
that's
right.
clear. Thank you.
His
All right,
position is
well, Mr. Jackson, you can stand up again.
his position is that Karen Reed didn't hear it, and that discussion did not involve her until the next day.
The defendant pursuing a third-party culprit defense.
That's going to be my
This
colleague,
is-
Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's
This is
sort of
a
a yes or no, and then I'll hear the Commonwealth.
Big
I'm
argument
sorry, I
for
did not
them.
hear the question.
Third party culprit.
Yes.
All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
She's going to rein him in. Brennan, make it fast. The court granted this motion last time. The court allowed this in last time. New trial, new arguments. The Commonwealth, we're in the Commonwealth's pretrial motions in limine. The Commonwealth is trying to exclude any third-party culprit defense, and then the defense is going to argue for it. The court let it in last time. I imagine the court will let it in again this time. I don't think much has changed to change that ruling of the court.
Jimmy, keep track.
But this is the Commonwealth's motion.
Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense
you're
presenting any evidence or questioning any witness about third-party culprit the defense needed to provide a sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit.
No, they weren't.
And thereafter, throughout
The very first words of opening were Karen Reed has been framed or was framed. Something. Karen Reed, connector words, framed. I think that goes to investigation more than third-party culprit, but I think we can nuance that a little bit more. But I don't think that, I don't think that counts.
the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from
Thank you,
the
Chat. Chat
defendant's
is like, it was
statements that there was a position
Was.
taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That
What's said on
position
the courthouse
changed
step doesn't
in
matter.
the Ted Daniels interview
That doesn't
when they were
matter
asked
either.
about third-party culprit, Mr. Jackson, and the defendant said they did not know. And
It
so
has to be
despite the recent
established.
position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert.
She said
And
among
so there's
others.
this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have
The court
now
did put
is
parameters
the
around
defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and
That's
they
true.
can't just come in and start accusing people arbitrarily of committing the crime of murder.
Also true.
Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit.
I know the law,
Your
sir.
time is up at this point.
Sit down,
I've
Mr.
read
Brennan.
your motion, I've read your memo,
Okay,
or the pleadings.
Thank you.
All right, Mr. Yannetti?
Y'all, I know you think that this court cuts off the defense more than the Commonwealth, and I think there are times that she does, but she is not having it with Brennan today. She is not having it. I gave you 2 minutes. Sit the fuck down. She's not having it. She is over it. She meant there was a limit. Do not come in here and repeat your moving papers. If there's something new, I want to hear it. And cut him right off. So I think Brennan has overpushed his luck with the court.
Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this.
Jim's on the clock. Jim, clock it. Stand up when it's done. Sit down. I think this is the court's way of trying to rein in the infighting between the attorneys.
In 2 minutes.
When it's done. Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll
That's
hold
fine.
it to the end.
That's fine.
All right, Mr. Alessi, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrite demonstration. I'll
Fair.
hear you for 2 minutes on that.
She's like, all right, you're going to the end.
My 2 minutes start when I get to the podium.
He's like, when does my time start, Your Honor? Do my 2 minutes start where I get to the podium? No, Alessi, we're in winter guard season. It starts when you get on the floor. You got to roll out the floor. You got to bring in the props. Your time starts when you stand up.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was.
No, I did not speed him up. He sped him up. He's like, 2 minutes, great, talk fast.
Stored within Jen McCabe's cell phone. That's it. No elaboration what it's going to be. They're looking to me this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance.
That is vague.
Again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrite software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property. And the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
Damn,
I appreciate
Alessi.
your brevity too. Thank you.
You're welcome.
The court, I appreciate your brevity. I see a lot of you in the chat saying 2 minutes doesn't make a lot of sense. The attorneys have been essentially restating their written papers. The court reads their moving papers and preps their moving papers. So unless something specifically needs to be highlighted, they don't need to just restate their moving papers. And the court's like, we're running out of time. You can't just restate your moving papers. Some of this needs more argument. Some of it doesn't. But I think on this, Alessi pointed out the issue that we've had with a lot of the Commonwealth motions. They are vague. They are vague. They don't say what the Celebrite demonstration will be. Now, we saw it in the first trial. But is that what they're proposing to do? Are they proposing to expand it? So it's really hard to argue against an amorphous, we will show things. Okay, well, what? So I get where they're just like, stop it. Brennan's gonna.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at
Put
the
it in
first
your moving
trial.
papers.
No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde,
Why don't you just say that then? Why don't you just say that in your moving papers? We propose to present the same experiment that was presented in the first trial to illustrate to the jury this point, this point, this point, this point. Put it in the filings. That's why there's filings. The filings are supposed to be specific.
provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay, thank you very much.
And look
I'll
at
get a
that.
decision quickly to.
Look at that. The court gave them rules and parameters. Nobody, Brennan, said, I'm regretful. I regret. There was no time for shots at one another. I think this is the court trying to rein them in. And look at that. Everybody just hit the high points. Amazing how that works. Attorneys are like goldfish. They will adjust to the size of their container.
To you in that.
So that's under
the defense
submission.
intend to bring up any bad character or misconduct of John O'Keefe or any witness?
That's why my streams go faster when I have a hard stop.
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention
some of that's
offering
impeachment.
would otherwise be prior bad act evidence, but they think it meets an exception.
It depends
under the
what you
rule,
say.
Then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance
Ellie,
notice.
this is fair.
And a ruling.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
A week before evidence.
Okay, that's paper 587, Mr. Clerk.
Thank you.
I didn't see him look at Alessi when he said opening. Well, I'll back up. I didn't see it. I was reading the comments about lawyers being like goldfish. So I think they are confirming with one another, but I think they are conferring with one another. But we didn't lose much time, so I'm going to back that up a little bit.
I will not be doing the opening this time, and I do
Oh, I will not be doing the opening this time. All right. He did say it. I was reading the chat. Thank you, chat. You're the best.
Rule, then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right.
Interesting. I can't
So,
tell which
okay.
attorney he's looking at about opening. It could be Alessi or Jackson. But he said, I'm not doing the opening this time. So it could be Alessi or Jackson.
So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A
I
week
do keep
before
my own
trial.
notes
A week before the evidence starts.
to the best of my notes on the points that I think are important that I want to circle back to and impressions. I think my note taking has gotten less like I would if I was
Okay, that's
arguing in
paper
court and more like
587, Mr. Clerk.
my friends who are judges, more like what both sides are doing so that I have a record of where I'm at
Cole's
and what I'm
motion.
thinking.
For an offer of proof
And my
regarding
impressions.
calling District Attorney Morrissey and victim witness advocate Steve Nelson.
I want to hear all
And it's
about this.
it also includes a
Give them more than 2 minutes. Give them more than 2
request
minutes.
to exempt from sequestration.
Your Honor, with regard to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product, so any such offer of proof, we would ask we make that ex parte.
That's fair.
I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly, we could make those offers of proof at the appropriate time.
That makes
Okay.
sense.
Thanks.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would
He
like
can't-
the victim witness advocate to be able to.
You
Yes.
can't be unsatisfied with that. That just comports with the law.
The victim witness advocate, he'll be able to come in for trial.
Yes.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Yes.
All right, so
Fair,
they're
fair.
both exempt from sequestration.
Good move. I don't think it would be a good look to have the elected DA in this courtroom. Whether or not they're exempt from sequestration, I don't think that'll help situation at all. At all.
Okay.
Look at how much we're moving along after lunch. Everybody got a little food.
The other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So
The court's like, can we
the
please?
Commonwealth's
zoom?
motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded
Proctor.
allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it.
Oh, yes, it is in a little bit different posture now than when the Commonwealth filed it, seeing that Proctor has since been fired and that IA investigation is complete. So let's talk about it. See, this is where argument's appropriate. Things have changed since the moving papers were filed. Let's talk about the shit that's changed. Shall we?
Back on March 10th, right?
Let's-
With Michael
let's hear
Proctor
it.
being fired.
The court's aware. I'm gonna turn this up a little bit.
Do you need some time to reconfigure this, or you want to just be heard?
Just
and
here-
for this, I'll give
Just talk it out, Your Honor.
you both 3 or 4 minutes.
I think it would be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us, to both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review.
Oh,
I'm
that's
expecting
fair.
that there may be many pieces of
That's
material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd
That's
object
fair.
to. Traditionally, ultimate findings or opinions of an advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to
Well,
provide them?
they have a copy of everything that we got.
Oh, okay.
So
everybody's
we
got
had
it.
them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in?
The firing can. Conclusions they're going to argue about. But the firing absolutely can.
Whatever their position is, maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably
You kinda
object to.
should, though.
The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
Is that a same timetable you would have whoever's arguing for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in
That's
the
fair.
motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but
But
there's
there's
just
internal
inconsistencies between
inconsistencies.
the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what.
I just have to point out that Attorney Little, and this has probably happened to her in her career, it happened to me in my career, Attorney Little rolls with being cut off so much differently than some of the other attorneys who I think are maybe less familiar with being cut off literally all of the time. She rolls with this judge so well. I think it's why the judge defaults to ask Attorney Little stuff, because they communicate well, and she just rolls with it and keeps going, where the other attorneys are just like, they're so shook. It's like, oh, of course. So it's funny watching the difference between how she rolls with it vis-a-vis how the other attorneys roll with it. She's just so ready to go. And I bet she was diving into those files the second they got them, because wouldn't you be? Like, give me everything in that IA file about Proctor. All of it.
To address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about,
Say, when do you
so
want
that
them
I
to come
can do
in?
it next weekend, and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay.
So Monday the 31st?
Does the
Yeah.
court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
He does not need till next Friday. There's a weekend. He could file that by Wednesday. He just doesn't know how voluminous it is, so he's trying to give himself more time. But if the Commonwealth filed it by Wednesday, that would give everybody time before the Monday. Make him turn it in earlier, Your Honor. I mean, he might not do it, but
Right.
the 26th.
That's fine, Your Honor.
Can you
I'll move
have?
as quickly as I can. I have a lot of
Okay.
obligations over the
Ashley,
next
this
week.
is
I'll try
today.
to facilitate it. I just don't know.
This is today.
All right. Without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that,
Right.
right? So,
Correct.
Well, Your Honor, if they say one thing, that's fine. If they say 7 things, that doesn't
all
help.
right. So, Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed.
So a new
And when
motion
you-
in limine.
or that you feel
Proctor problems.
should be excluded. And when you
But you
provide
can't
that
hear
to the
that on the
Commonwealth, I'd
31st
like you to
then.
let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need.
That's fair. That's fair to give the defense that time. I'm surprised she didn't cut the Commonwealth's time, but the court's anticipating that jury selection is going to take a few weeks, and I imagine the court would be amenable to doing a half day to address it and scheduling from there, and has been pretty flexible with that.
All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you your 2-minute, when I cut you off after 2-minute on third-party culprit. And then, Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti.
He's like, no, it's not.
Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're-
last time I,
Your Honor, it just depends. What are you going to do? How much do I need to argue with you, Your Honor? How much convincing do you need? Are you just like, yeah, sure, I'll order dessert? Or are you like, there is no way I'm splitting a lava cake with you? Like, where are we at? Are we at, sure, I can be convinced? Or are you at, there's not a fucking chance in hell? Like, where are we at? I'll tell you how much time we need when you tell me how opposed you are.
said I wasn't excluding it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear the different sides. So
if that's the ruling, Judge, I don't need to be heard.
And I know, Mr. Brennan, you wanted it in advance, but, I guess I'll hear you on your motion on that then.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness. There is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit?
Well, they
what
claimed a
evidence do they
conspiracy, so
have that
multiple
they want to
people can be
introduce?
involved, is
There
what
has
they
to be
said.
parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about
There are
who
very
the person
specific
is,
rules
but
about
what
that.
evidence are they going to introduce? Otherwise, we're going to spend half the trial at sidebar fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to
Well,
identify
They can't.
who the third.
They can't do that yet because the evidence has to come in. So, at best, you need a hearing mid-trial after witnesses have testified, and then you have this conversation. It's premature to have this conversation now.
Third-party culprit is, and what do they want to introduce? Do they have a witness? Do they have evidence? Do they have any records?
Look, you have to have
Simply
witness
assailing
testimony
people's
first.
character randomly is improper, it's unfair, and then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court whether we think it is appropriate or whether we think it's insufficient. But
And that's
now
what
it's
the
just
defense
an
said about
empty
most of
box
your
where,
motions today.
as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way
That
the
is
court
not the rule.
and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence.
Well, that's
They
not what
shouldn't
the court's
have,
going
they
to rule.
could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
All right, so, Mr.
Many of you are asking in the chat, so we're going to take a moment to answer it. There are rules and case law that govern third-party culprit defenses, and there are showings that the defense needs to make before you can get into a specific third-party culprit defense. That's not burden shifting as it comes to whether the jury has to find that the defense proved something. But there are many times in any case where the defense has to make a threshold proving before something, or threshold showing before something can happen. This is one of those cases where information needs to come in, and then there is argument, and then it comes in. The court has never said third-party culprit stays out. The court has said the showing needs to be made, and that's consistent with the law and the case law that a showing needs to be made. In the first trial, a lot of that showing came in during witness testimony, but there was never a pause in a hearing getting into it. And Lally didn't object. So there was not a point where the prosecutor said they're getting into third-party culprit questions and we haven't had a showing. The Commonwealth didn't ask. So the defense isn't going to be like, hey, are we there yet? Because the court didn't stop it. So it might be the case in this case where at the end of the prosecution's case in chief, when they do the motion to dismiss, they also address this then. And that would not be unusual. And that is when the arguments can be made with the showing. And then the defense would say the evidence that's come in so far is A, B, C, D, E, F, G. And that is why this is our argument. But Brennan is going to fight it. Absolutely. But again, the court's going to say, this is premature to take it up now. It doesn't come in during opening. And that's consistent with third-party culpability, like across jurisdictions.
Eddie, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third-party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
Some other dude did
I think
it.
it's the second alternative. In other words,
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell
And
us
that's
who
part of
last time you
part
told?
of the argument is the police knew everyone that was in the house. So you can't say the police aren't aware that people were in the house. The police were aware that people were in the house. And the defense is going to say, right, the police knew who was in the house and ignored it. So the argument shifts to there were other avenues of investigation and they did not follow them. And then the defense will have the room to argue and they didn't follow them because they're all hopelessly intertwined or other things. So that's where the court, I appreciate these questions from the court narrowing it down, A, B, or C, and the defense is like B, and they're like, okay.
Told me you don't have to prove that, but can
well,
you make
it's
an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Because the
Are you
defense was
saying
aware.
it's several?
Three, yes.
Okay, so can you tell me the three that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert.
And I think
have,
they've been clear on that.
Evidence with regard to each. I'm sensitive to the fact, Your Honor.
I think the defense has been pretty clear on that, arguing, hey, the police did not follow these leads because of how intertwined they are, and then tying that back to Proctor and saying Proctor didn't follow these leads because Proctor, A, had already decided Karen Reed had done it, B, had already decided that he fucking hated Karen Reed, as we see in the text messages, and C, wasn't going to investigate the buddies. That's been pretty clear since the beginning.
That, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
He's like, no, I'd love to put it on the record right now, Your Honor. Let me put it on the record right now.
I'm just sensitive to the fact that the court is seeking not to, pollute
Belabor.
the potential.
So we can do this over here.
It's up to Your Honor.
No!
Why don't I see you preliminarily over?
Brooke, I am using a stand desk today. I always have a stand desk. I'm standing today. So the defense said, hey, I am sensitive to the fact that the court does not want me to put this all out here, but I can make the preliminary. If you want me to put it in writing, I'll put it in writing. This is what they've talked about in the first trial. This is not different. And now we're at the OnlyFans. But we gave ourselves some Zoom room, so let's zoom to the Zoom room. All right. As we get past sidebar. I saw some of you ask, are Are they locking themselves into a theory? There can still be multiple theories.
The defense has to make a decision as to what.
I'm going to stop what I'm saying because I think the court is going a different direction than I am. It might lock them into the third party theory. I think they can still argue the investigation and the issues with the investigation. So that's where I see those as multiple theories, but those aren't multiple third party theories. Hopefully that makes sense. So multiple theories, yes, in that investigation, this, but not multiple theories with third party. But I don't know if they've had multiple theories with third parties. It's really been investigation plus the people in the house. So let's let the court.
The defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garret Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand up?
Like 2 minutes. Just my first question is...
How would you like to do this, Your Honor?
Who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby.
Oh.
And he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, is to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration.
They asked to reconsider.
Whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it, so I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all
That's true, he is.
all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
Yes.
He's like, that's
Is that
3 days.
acceptable, Mr. Brennan?
Yes, thank you.
All right,
Thank you, Your Honor.
thank you. So 6:07.
All right.
Is the defendant will provide reciprocal discovery by Monday, the 24th.
Done and done.
All right, the
What's next?
Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figured this is probably lengthier than the others.
All right.
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
This is a Commonwealth motion with regard to a defense expert.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having...
I think there is room to bring in experts on how police investigations go, what a chain of custody is, and things like that, because the defense can't just give a testimony that this is not how an investigation should go. It is not unfair to bring in someone who is an expert in police procedure to give their expert opinion, which is probably also personal to them, to explain something that's outside the purview of the jury. Because what a normal investigation or a typical procedure looks like is outside the normal purview of the jury. And most law enforcement agencies have policies and procedures, and experts can review those policies and procedures and say these weren't followed. But an attorney can't do that and give that information. They can cross-examine on it, but it's a time when having an expert might be helpful. So the Commonwealth is asking to keep it out. Rachel ID said, wasn't there a really good expert on this in Murdaugh? Yes. There are experts that testify about this in cases regularly. This is not an odd ask.
Having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses.
Policies,
and then the witness would
procedures.
have the opportunity to respond or explain or admit any type failures. This is
going to be real interesting after the Proctor findings, because it's going to get real interesting, because Proctor's supervisors are going to testify too. So police procedure is going to get real interesting.
an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go
what are the
through
opinions? Can you
protocol
list them?
of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in,
through
promote the
protocol.
defense theories, tout reasonable doubt, and
But they can, what? They can cover policies. What are you talking? What?
and suggest why somebody else committed the crime.
That
I've
they
done
might not
quite a
be
bit
able
of
to do.
research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013.
So you're saying that law enforcement agents don't know what the proper policies are of law enforcement? The FBI, that's where we're at? That's where we're at. Okay. They're allowed to do that. They can review the policies and procedures of a department and say, this fails to meet those standards. The defense attorneys can't testify to that. They can cross-examine on it.
He is not in a position.
He's an FBI agent. What the fuck does he know, Your Honor? Okay.
Personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records. Rather, a summary witness of a witness who wants to come in and give their personal opinions about this case.
They're
I don't
introducing it
see
as
any
an expert
grounds for
witness, not a summary
admissibility
witness.
for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their
Doesn't
case
the
and in
FBI
their
like determine who
cross-examination. So
subjects
I
and
don't see
suspects
any
are?
relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant?
Okay.
I need you to start by telling me what you expect him to testify to.
Yeah, because he should have done it.
Certainly tell the court that we do not expect to seek
Because the Commonwealth has conflated, and I'm interested to see, because the Commonwealth didn't say this expert's opinions are A, B, C, D, E. An expert that comes in and says the policies of Canton PD are X and this investigation had Y is very different than this person should have been a suspect and this person should have been prosecuted instead. Those are very different things.
Testimony or illicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it?
I'll go through
Is it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many.
Has this never come up in one of this judge's trials? This isn't like new. Like, I don't know. I'm not a defense attorney. I've never worked as a defense attorney, but quite a substantial amount of defense work is the police didn't do their job. How is that a field? What? I'm so fucking confused. How is this not normal? Because this is normal. This happens all the time.
Any of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter.
They probably fucking do. They probably do. Because I imagine when they're like, that's a Stop and Shop bag, that the jurors were just like, the fuck did you just say? Because that was my response. That was y'all's response. Y'all's response was, the fuck did you just say, solo cups? So it's fair to bring in an expert. I think the chain of custody is more substantial. And I think once the jury understands it the way we understand it, that the jury will also be appalled by it. I think the solo cups are one of the obvious ones.
And that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to, or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is it
how evidence gets logged?
Is the basis of his testimony just crime scene, like collection of evidence?
No, it's also it's investigation.
Witness interviews.
When somebody tells you somebody may have done it, you're supposed to go follow all those leads. Which is it?
That too. Both. Because of
But also interview recipient witnesses separately. He can't come in and say, I did an investigation of this case and I would have charged this person. He can come in and say, I looked at this investigation. You don't interview witnesses together who are recipient because of these reasons. Not that I'm saying these reasons happened in this case, but because there is room for witnesses to be tainted by one another's memory. It's like when you're out with friends and somebody's been, drinking, or everybody's been drinking. It's Canton. Everyone's been drinking. And the next day it's, hey, so I remember this, that. And somebody else is like, oh, but what you didn't know is this, that. And then your memory of the event changes because you have more information. It's why you don't interview witnesses together, because then it's real hard in your mind 2 years later to separate out what you saw, what you heard, and what you were told. But that can be explained to a jury. Not saying it happened here, but why it doesn't happen in a broader sense, just like any other expert.
Someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing,
chain of custody,
logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept,
right?
How you bag evidence, how you secure evidence, how
Bag,
you maintain
tag.
the integrity of evidence, and things of that nature. There is certainly,
and an expert might say, in this circumstance, depending on the time of day, taping off the crime scene doesn't make sense. So you would just put a vehicle at one end of the street and a vehicle at the other end of the street because the weather was so bad. I mean,
I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the
Testimony of
advisory
expert
committee notes for
witnesses.
federal rules of evidence 702 is very, very instructive on this particular.
a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion.
Issue is it specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge.
I mean, you can be an expert in furniture making or leather working. If it's relevant to the case, it's relevant. If it's outside the common purview of the jury, it may be relevant to the case.
Not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education.
Oh, he's going to read it for us.
Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the rules of evidence 702,
the regular knowledge of
the
a
federal
juror.
rules of evidence 702 clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions.
This is not a weird ask.
I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formerly coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally.
LA's busy.
He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local.
AJ, how many times have y'all worked together? That's my question at this point. The court just heard LA and went, but Mr. Jackson, crimes are different in Massachusetts. He doesn't understand the snow.
Agencies with investigations and prosecution
he worked with robbery,
thousands of homicides, robberies, kidnappings, other violent crimes.
LA's busy.
His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in
Yes,
some of
just list it.
the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all
I don't
that.
need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either, what I was reciting is either in the CV or in his report, one
Okay,
or
so
the other.
that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like from
So
me.
I
Do you have
wanted to know
specific?
specifically what you intend to have him testify
Michael Bailey,
on. But
that's
if it's
funny.
in his report,
It's in his, it broadly is in his report.
What do you want to, how are we confused, Your Honor? What do you want him to testify? Has she never had a case where anybody brought this in? This isn't uncommon. Why are we so confused? The judge is just like, what is he going to testify to? That this investigation was shit, Your Honor. That, like, chain of custody matters. Interviewing witnesses separately. He's going to testify about the investigation. How are we not on the same page? I am so confused. Oh my God. How are we confused?
I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes, obviously, we're going to ask him, we've already asked him, to review.
So this
he's
investigation,
reviewed,
lol.
NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices.
His
for an
opinion is
investigative
lol.
so I guess
technique.
that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it? Or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced.
You're a criminal judge. You're a criminal judge. I realize that y'all ride circuit and y'all go back and forth between civil and criminal, but you're a criminal judge. Where are the policies and procedures written down? Well, there's like fields of study. There are committees that go through arguing for best policies and procedures. There's like standards and national standards and organizations that go through that. And then each department codifies those. How do you discipline Trooper Proctor for violating departmental procedures if there aren't any departmental policies and procedures? How is this the question right now? What?
Seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it?
Ask
Or is
the
it
police
just
board
his
that
experience?
just fired
No, it's
Proctor
not
where
just his
those are.
experience. Those standards and practices are
Holy
oftentimes
shit.
reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills
There's
and that
national
knowledge
standards.
base to assess
Canton has
his
standards.
opinion or to render an opinion
Or
and
should.
a conclusion concerning
I've not seen
what
them. I
he
can't
believes
affirm.
are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think
All right.
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
You have an email where the police chief turns over a video late and the email says lol. And you're just like, what are standards? What the?
Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin, How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by...
Tell me how accident reconstruction is not Monday morning quarterbacking. Tell me. Tell me how accident reconstruction is not Monday morning quarterbacking. Tell me how your new accident reconstructionist who's replacing Trooper Paul is not Monday morning quarterbacking. Explain to me how that's not the legitimate purview of experts to come in and say things should be done differently. It's literally all that appellate courts do. Appellate courts look at what the trial court did, and then they look at what the law is, and then they go, oh, well, shouldn't have done it that way. Brennan, what is happening? It's literally...
counsel so that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation. I don't...
Sir, have you been paying attention to this case? Sir.
I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to us,
They're going to end up with the defense being like, fine, we'll just bring in the police standards board that disciplined Proctor. If you want to talk about whether statey police procedures were followed, we'll just bring in all of them. Proctor was fired because of his failure to adhere to the department policies and procedures. For fuck's sake. What are you on about?
state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to
Like a Gatling
have an
gun?
opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they
You can.
explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases. I've looked through the state.
Is this... What? Why is this weird to you?
In federal court that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden type witness in any court. He may have testified, but about what? And so I think this is a very
I'm gonna let him
dangerous
finish.
proposition.
I'm gonna let
what
him
if
finish.
the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody...
How do you bring in a witness to say the investigation was fantastic when the lead investigator was fired for behavior in this investigation? How do you even make that argument? What is happening?
They did a remarkable job under the circumstances. What if we bring in a witness to talk about the fact that the evidence is so overwhelming?
The defense will say that you are bringing in witnesses to perjure themselves. That's what they would say. They would say, "Oh, Your Honor, the Commonwealth would like to bring in a witness to say this was the most fantastic investigation ever." And then they would say, "We would like to make sure that perjury does not happen in this case." Oh my God. Oh my God. This isn't weird. I'm going to try to let him finish. I'm losing my mind. I'm going to eat pretzels and shut the fuck up.
On a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances. What if we
evidence
bring in a witness
would
to
work
talk about the
hard
fact that
against
the
you.
evidence is so overwhelming that it should imply a certain finding by the jury?
That is the worst straw man argument in court. That's not, that
Invites that. This
No.
invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Your Honor, very briefly.
the point is that it's not argument by counsel because it's improper for it to be argument by counsel. So you bring in an expert to talk about what policies and procedures are. That part.
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that.
Evidence?
It's called presenting a defense for someone charged with murder.
Your Honor, it's like having a reasonable belief that my claim deserves evidentiary support. That's like what we do. That's the job. Oh my
He
God.
indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were?
It'll be laughable, but sure.
There's another word for that. It's called rebuttal.
What? What? Where did the stream go? Where did the stream go? Where did the stream go? Oh my God. I am going to lose my mind. All right, let's see if we can find it in time. This is the rudest stream glitch I have ever seen. My brain is going to explode. That's the worst fucking cliffhanger ever, law nerds. I'm so sorry. It's brutal. I'm so mad. All right, let's see if we caught Brennan midstream.
There'll be a separate grounds of whether they're admissible and whether they can confront the...
I think we are not back far enough. Let's see. Nope, that's Alessi. I'm trying to find where we were in time. All right. That is Alessi. This looks like when Jackson gets up. Let's see if this is the first round or the second round.
So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling.
Okay, this is round one. All right. Let's get back to where AJ came up for round two. There we
A
go.
shot like a shotgun approach that will never be able to...
Gatling gun opportunity missed. Truly. And the reason I keep saying that is because Alessi put it in one of his motions, and we know how much they love the vocabulary of Alessi. All right. We'll let AJ start from the beginning.
I gently disagree with Mr. Brennan.
I gently disagree.
He indicates that we want to use
evidence.
an expert to bolster our argument.
Have you been to court before?
There's another word for that, or another phrase for that. It's called presenting a defense
This is
for
wild.
someone charged with
Where
murder.
are we?
He indicates, well, what are we going to do?
Massachusetts,
This guy's
I'm
going to
sorry,
get
I
up there and
forgot.
testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
You wouldn't
hang on.
be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Mr. Brennan said, what if I...
He's like, Your Honor, please make my day. Make my day. Make my fucking day. Make my day. Bring in an expert. Bring in an expert to tell me this was a fantastic investigation. Bring it in. Bring it in, bring it in, bring it in. Why? Because it's going to open the door to all of the Proctor shit. Bring it the fuck in. Your Honor, I would invite the opportunity because it will bring in so much more of the Proctor stuff. Because you have a lead investigator that's been fired after a 3-day trial. And while they can cross-examine him on being fired, if you bring in an expert to say this is the most fantastical investigation that's ever happened, it's going to be 2 days of covering Proctor's disciplinary actions. Your Honor, don't threaten him with a good time. And the fact that he didn't say that is him restraining the LA. Don't threaten me with a good time, Your Honor.
A great investigation.
Did you see his whole face light up?
Talk about how great their investigative techniques were. Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well,
You wouldn't
hang
be
on.
objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words.
Don't.
Do it. Do it. I'd love that. I'd love.
God damn it, AJ. Can you please say that a little bit more like Palpatine? Do it. Can we go full Palpatine? Do it. Don't threaten me with a good time. It's like when defense attorneys are like, my client might testify. Uh-huh. Mm-hmm. Mm-hmm. Do it. Do it. Do it. Oh my God, today.
Oh, no. Oh, no. Mr. Brennan
That was
said,
hilarious.
what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it. Do it. I'd love that. I'd love a shot at that.
So I said let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in?
Your Honor, you asked, Your Honor. Your Honor, you said, so you'd be okay with this. And he said, I would literally like nothing more in my life. Except maybe a new Maserati. But I would like nothing more in my life than for y'all to do it. Do not threaten me with a good time. You asked, Your Honor. I'm not taking personal shots. I'm just saying that would be the most fun ever.
Another expert, that's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within
The purview of the jury.
There's, so if you can give me a case site for that, all right, that expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So
I've got
like
it.
A case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and
What?
searched for a specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point. But there are
Really?
plenty. There's a myriad cases outside the jurisdiction where investigators are called consistently,
time.
especially on behalf of the defense, to talk about adequacy of an investigation. That is an expert field, one that's utilized throughout the country all the
some
time.
authority, and the more persuasive the authority.
The court saying they've never seen it can mean 2 things. It can mean A, defense attorneys don't do it and don't bring it up. Or it can mean B, it's allowable under the law and it's never appealed. And if it's never appealed, it doesn't end up in cases because it just happens. So if something just happens regularly, you would never appeal it. It would never end up in case law because it's so normal. It would be like somebody saying, where's the case law authority? Actually, that's probably statutory in the rules of civil procedure. That was a terrible example. But there are things that are normal parts of the process that fall within the rules that don't get challenged. So there's not case law about it because it doesn't get challenged. But her saying, I've never seen the case law on it and I've never seen an expert be presented on it, maybe it doesn't happen regularly in Massachusetts, which is also wild. Because the chat came up with like 7 cases off of the top of mind that y'all have seen this in, including Murdaugh, where we saw it.
The better chance you have at this. Okay.
Sure.
But I think it falls under expert.
So
I think it falls under
that's
expert.
it for the motions in limine.
Wow.
Did I miss anything?
That's wild.
I need that. Oh,
This is where they need the defense bar in Massachusetts to reach out to Yannetti and Jackson and be like, hey, these are cases where it's happened and it's never been appealed. Because that's where the defense bar often uses their collective knowledge. We saw that a lot with the defense bar coming together in the YSL case in Atlanta. That's wild.
Your Honor, earlier you alluded to...
Wild.
The defense wanted to talk further about the ARCCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first.
I thought so too.
Is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
And Brennan didn't do his homework.
I regret we have not spoken.
If I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional
Sealing it?
one-page
Oh.
juror questionnaire
Interesting.
that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate
Right.
questions. If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment. It makes sense to me.
I'm sorry, Your Honor, I was looking at for outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties.
Not
All right,
snacks. I was thinking about snacks earlier. I do remember that Brennan brought up Dr. Kenny Kinsey. I just don't remember the full context. I remember it came up, like he's seen it happen, but it happening in South Carolina and it happening in Massachusetts are different. This is wild.
File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need
Well-
that by tomorrow. So tomorrow.
Y'all, I have refrained from talking much about the judge, but you start calling a venire and you are going to lose me every single time.
Or by the close of business.
I
need that.
cannot.
So, if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Obviously, it would be a day after Monday then, right?
Yes, Mr. Unity, it would be after Monday.
We did file 2 motions today that at some point we'll need to hear on.
Everybody's just now low talking. I'm going to try to turn this up a little.
Okay.
Defense.
That sucked. Apologies, law nerds. We turned it up way too much.
Just received notice this morning, so been prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
Why don't we come in next week? Why don't we come in next week? Today, man. Just and a number of you in the chat, or maybe one of you in the chat, a number of times pointed me to Mass Rule of Evidence 1107. We'll get there. We'll get there before we wrap. I think they're, well, let's see if they come back on the record. No, they don't. All right. I don't know if they came to a conclusion. I guess we'll have to wait and see what those in court say, because the feed cut. I'm going to ask you guys a question because I do have a meeting today. So I'm going to ask y'all a question in the chat. we're going to go to that evidence code section, but I'm going to start a poll and I'm going to let chat decide because we're not going to have time to do it all. And so I'm going to go with what chat decides. What next? Let's see. If we do the hearing from this morning, we are not going to have a ton of time for Q&A. If we don't do the hearing from this morning now, I will do it a different day, but I will not do it now, and we will not have as much time for Q&A. Does that make sense? So I'm putting up the poll about what we're doing next. I'm going to pull up this rule of evidence real quick. Thank you to those who pointed out in the chat. Look, Law Nerds or Bay, you are the best research attorneys in the world, but we can only pick one thing because I will not have time for both. And I do have a hard stop today. And we've been streaming for 6 hours. Let's take a look at Massachusetts rule of evidence because this is going to come up. This is going to come up quickly in court. Massachusetts Rule of Evidence 1107 as amended through December 27th, 2024. Again, research attorney Law Nerds, thank you for pointing me directly to this. Let's take a read of this. Section 1107, inadequate police investigation evidence admissibility. Evidence that certain tests were not conducted, that certain police procedures were not followed, or that certain information known to the police about another suspect was not investigated, in circumstances in which it is reasonable to expect that the police should have conducted such tests, followed such procedures, or investigated such information, is admissible. And there's a jury instruction. Let's see what the notes say. Subsection A. Subsection A is derived from Commonwealth versus Bowden. Evidence concerning the inadequacy of a police investigation is known as quote unquote Bowden evidence. A defense based on the inadequacy of a police investigation is known as a quote unquote Bowden defense. A defendant may argue that deficiencies or omissions in the police investigation create a reasonable doubt as to the defendant's guilt. I think this is a much better process for the defense. I think this is a stronger defense. Once determined to be relevant, Bowden evidence is admissible unless its probative value is substantially outweighed by its prejudicial effect. All evidence falls under that rule. Commonwealth versus Mattei. Judge erred in refusing to permit defendant, a convict on work release, to question police about their failure to investigate criminal records. But that is questioning in cross the police. That's not bringing in an expert. The Bowden defense is a two-edged sword for the defendant because the introduction of Bowden evidence permits the Commonwealth in rebuttal to explain why police did not conduct the investigation suggested by the defense. Fair. And, quote, the more wide-ranging the defense's attack on the police investigation, the broader the Commonwealth's response may be. In some cases, that might be a problem. In this case, it might be less of a problem. They cite in the notes Commonwealth versus Brum, not error to admit otherwise inadmissible inclusive results of DNA and blood tests conducted by police where defendant attacked adequacy of investigation. However, a broad Bowden defense does not render the devoid of evidentiary constraint. The trial judge must be alert to the potential that the rebuttal evidence may come close to or cross the line between a permissible account of the police investigator's rationale for pursuing a certain suspect or investigatory discern, and an impermissible expression of opinion of the defendant's guilt or implicit comment on a witness's credibility. I think the defense will be relying on Proctor's credibility and Proctor's statement of, well, this is why we think that Kearney did it. If Proctor has no credibility, it's not going to really help. So let's see. Comparison between Bowden and third-party culprit evidence. This is not going to touch on experts. But if the defense is saying they have not found case law specifically on point, it's because this statute doesn't exclude expert testimony. They're allowed to admit evidence that tests were not conducted and police procedures were not followed. If you're allowed evidence of that, you I don't think are restricted to evidence being presented in cross-examination rather than an expert. We'll see what the court decides to do. Make sure you have the Lawnerd app, because whenever we go back to court, whether it's next week, I'll take my travel setup with me, whether it's next week or not, because it'll probably be docketed today or tomorrow. I will keep you in the loop in the Lawnerd app. It is free. It will send you alerts when we are live. This trial looks like it is going to start jury selection April 1st, but probably won't start evidence until the end of the month of April. So we probably have a few weeks, and then it's going to get real squishy on trial schedules, which is going to be really interesting. So on the Lawnerd poll, 79% of you said, hearing this morning, do it. Do it. Wayne said Tuesday at 11:30. Wayne, I hope you're fucking with me because I'm on a plane. Wayne, I'll be on a plane. Though that's probably accurate. That's probably accurate. And then I'll cover it later. So for those of you that voted, I will try to get to some super chats if we have time at the end. If I did not pull them up already and did not get to them, I will be going through them. We're going to go to this morning's hearing. It is a shorter hearing, and I think we can get through it before my hard stop. So let's look at the hearing from this morning. I'm going to go ahead and end the poll because we have over 3,000 votes, and y'all were like, do it. I'm not going to stop. I mean, maybe eventually, but definitely not today. Definitely not today. Oh my goodness. AJ literally said, don't threaten me with a good time. I'm not surprised by that. Because, well, I mean, I think any defense attorney faced with what is in this case, especially since Proctor's been fired, would say the exact same thing. Literally the exact same thing. All right. I'm going to zoom till we get into court this morning. Remember, court this morning is related to Brennan's motion for Turtle Boy's phone records from his cases so he can use information from those requests in the Karen Reed case to go to her consciousness of guilt. So that's where we're going to that hearing. You will see that it is with a different judge. Oh, Miguelina, you're the best producer in the world. Thank you. Miguelina's like, I grabbed it with the timestamp. Thank you so much. Let me just pull it up. It's my understanding that this is the feed that starts on time, that the other feed that has closed captioning does not. I will try to be mindful of pausing when I interrupt so that we can hear, even if we can't see, so we can hear. So let us go back to court. Let's go back in time. We're going to time travel just a little bit. I might need a TARDIS noise on the soundboard. How do you think that would go? Would it immediately get me copyright claimed? I wonder if it is copyrighted. Anyway, we're going to go back in time. So that's what we're doing. That's going to have to work for now. Back in time to this morning to look at the hearing that took place before the hearings in this case. So let us go to court. Yes, this cuts in a little bit of the middle, but Miguelina was looking this morning for the feed that started the earliest. So we missed a little bit of the intro to the case, but here we are. So this is a different judge evaluating whether or not those phone records from a separate case will be turned over. So
He says under these circumstances.
oh, we have Doctor Who's permission. Perfect.
A Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed.
The feed is a little choppy. So just, it's not you. It's not your internet. It's not you. It's the feed.
Prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Kearney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Kearney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are two pleadings as well in my motion that are on the public docket.
That's as much as I could turn that up,
What I
y'all.
learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Kearney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Kearney. Originally, a third party was used, an intermediary, where
He said suggestive of grand jury. Public information is different than private information.
actually Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask
from
you
the
this,
name.
counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue.
But it very well
here
may not.
With regard to the
Like if it very well may, it very well may not.
in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Kearney's phone, is that there was a relationship between Karen Reed and Mr. Kearney in which Ms. Reed would provide information indirectly to Mr. Kearney. That information would then be reviewed by Mr. Kearney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Kearney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Kearney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit.
He's like, I can
in support
read.
of the search warrant
Move
thoroughly.
on.
And
A lot of you have asked, how is this different than if Karen Reed was never indicted for this, if this is not a criminal case going forward? Using information to show consciousness of guilt is a different standard than prosecuting someone, bringing criminal charges. They are different. So we're talking about an evidentiary standard, not a criminal standard. So they are different, but he's arguing that he should be allowed to get this information because he thinks it will lead to information that he can use for consciousness of guilt. And that might not be concrete enough to get him there. Generally, with consciousness of guilt, you need concrete evidence, and there are quite a lot of cases and parameters that look at consciousness of guilt. We've seen these arguments in like the Donna Adelson case with the flight to the Philippines and whether or not she was taking a vacation or whether she was fleeing the country so she didn't get arrested. They're arguing consciousness of guilt. She's bouncing. So he's trying to say consciousness of guilt because they are trying to harass witnesses so they will not come to court. That's the way he's trying to bring this in and to get this information. He doesn't have this information yet. Lyndon said Vietnam. Thank you, Lyndon. I totally forgot. I was probably just thinking of like lumpia. I was just hungry. So Vietnam. Apologies. So he's trying to get to that information that he doesn't have yet. That's what he's arguing.
And here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So
Right.
to demonstrate,
I like this, Judge. That's a hard burden. If you don't know what the thing is, how do you show it's relevant? Because Brennan's argument is a lot of it may, it could, because he hasn't seen the thing yet. So how do you get to seeing the thing if you have to prove what the thing is and you haven't seen it yet? Right.
here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant.
Initial factual
Relevant.
showing. Right.
That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I think
I'm
that's
not clear on your
fair.
question, Your Honor.
That makes sense.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt?
Probably not.
Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit
like,
in support of the search
Well,
warrant.
shit, you're asking good questions.
It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites,
That's a
text,
lot.
videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant.
Oh, well, there's Karen Reed's team.
How can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so
They're all just like walking up, sitting at council table? What is happening? Karen Reed's defense team and Karen Reed just walked up to go sit at council table. But this is not their hearing. I'm going to let it play. That's odd.
With communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing?
Also, walking in to council table while the court is on the record is a lot.
Those are relevant.
first, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed, because they have standing in this.
You just said, I'm not sure why we're being joined by Miss Reed's team. I'm not sure they have standing in this. Oh, boy.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Counsel, can you state your name for the record, please?
Yeah, you just did.
Alan Jackson on behalf of the Court. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights.
Well,
And
then.
the
This
issue
meeting is being recorded. Counsel, it has been called in this case, but but I don't know that
That doesn't
your
mean-
client has standing with regard to this particular issue.
Right, because it's not her
So the case
phone.
number- I just want to make sure procedurally I'm on the same page as the court and Mr.
The Rule 17 is regarding whether or not the information from Turtle Boy's case can be given to the prosecutor in Reed's case. It doesn't address Reed yet. The evaluation of whether or not that evidence is then relevant and admissible in Karen Reed's case is something she can argue, but whether that discovery can be turned over is something that goes to the other case. But the court's like, it is under her case number. Okay.
Brennan and Mr. Kearney, the case number that was called.
Oh boy.
Been called in this case, but I don't know that your client has standing with regard
Well,
to
if the
this
judge said it's under this
particular
case
issue.
number,
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
And she needed to be
that's her case. Freedom Ring said, but it's still her records, not technically. It's Turtle Boy's records. It's not her records. It's his records. Even though information she might have sent him is from her, but it's filed under her case number and the court called her case number, but it's his records.
here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward.
Oh, boy.
In terms of her case, I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a
His records,
Rule
she does.
17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
He's not asking for, I disagree with you, AJ. I understand why you want to be there. I think you have a right to be present. I don't think they can keep you out of the courtroom. I don't think it's a closed hearing. But it's not her records. This is a two-part analysis. First, does Brennan get the stuff? Second, can Brennan use the stuff? Those are two separate things. This court is not happy that they just walked in while the judge was speaking and sat down at counsel table. Oh boy.
Those are evidentiary issues, counsel.
Correct, but
That's what I just said. I'm gonna let it roll. Emily, just shut up and let it roll.
Related to documents produced in
I
another
like
case.
this judge though.
because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but we
Which
I
can be
like
dealt
this
with at a
judge.
later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I
This is,
understand, and respectfully, I don't necessarily disagree that
I like this
from an
judge a lot.
evidentiary standpoint or the disability standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to
Use
deal
it in her
with-
case.
With her case, not Mr. Kearney's case.
Right,
So
right.
She has to have a right to be heard.
counsel,
That's
this,
our belief.
counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And did you
prepared.
give the court notice of that?
We did to Justice Kearney,
Okay.
day before yesterday.
Oh boy.
And what do you propose?
I have a proposal, Your Honor. Your Honor, can we operate a trade? Because I feel like the court is not having any of this, and I am living. I also understand where the confusion is, but Your Honor, I have a proposal. I have a proposal. Oh boy. And the defense is like, we're here now, bitches. We're sitting down. We're sitting down. We have a right to be here. It's called under her case number. It seems that there is some confusion about what that means. And there are times where things are called under a case number. We saw this in Depp v. Heard when the attorneys for TMZ came in to argue whether or not a witness could testify. Not all the parties have a right there. That's between the TMZ lawyers in the court and the party that subpoenaed them. So there are times that one or both of the parties are not necessarily directly involved, but in a criminal case, I understand the defense being like, this is her case. We have a right to be here. The hearing should not start until the defendant is present because you are calling the case of my defendant, and this is under her case number, not a Rule 17 under his case number.
Counsel.
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration.
The court's like, ugh.
Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
I don't think
Absolutely not, Your Honor. Again,
Kearney and his attorneys, I don't think give a fuck about. I think they're amused. He looks amused.
I just need to be in the courtroom, and once Mr. Brennan is finished, before the court makes an ultimate ruling, and once Mr. Bradle is finished, I think we should be
Amused.
provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my file, and that's an issue in terms of the filing. So just put it
Thank
down.
you. Thank you.
Yeah, defendant and his attorney are fine. They're not pressed at all.
Ms. Reed's counsel and Ms. Reed do not have standing for this
Brennan's
motion.
pressed.
I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
The defense team is like, no standing, you say? Fine. We'll just stand. She doesn't have standing on the motion. The evidentiary bit of it comes up. These have to do with Aidan Kearney's records.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion.
Yeah, because the court can't say this isn't her case number. It's under her case number. You filed the motion, Brennan.
So,
They're like,
ADA
fine.
Brennan, with the court's apologies for the interruptions.
It's the most awkwardly small courtroom. Shit got real awkward real fast.
The crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is
I don't think that's the issue. The issue is, do you get it?
Needed for a Rule 17 motion.
Do you get
pardon
it?
me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D.
But do you get it?
There was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
ADA Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel for Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed.
I think those would be
Kearney's
work
case.
product.
One is the Commonwealth's opposition.
At least he didn't
to the defense
argue.
Motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove.
Who is the special
And
prosecutor
that
in the
motion,
other
on
case?
page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth's revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she wasn't,
That's the Discovery ID series.
in fact.
Brennan is going to keep arguing things she said in that series and is using things he did not have when he filed this motion against Karen Reed because she said it in that series.
The video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney.
She did say public
And
information.
What is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and
She's like, I have a
understanding
clip of what she said.
to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline.
The court's like, miss me.
Respectfully, the offer, ADA Brennan.
Yeah.
Thank you.
The court's like,
So in light of the
nah.
fact that this information was
Keep it to the
pursuant
filings.
to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of this sharing, inevitably, the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own.
Right.
I think it's more prudent.
He's
to
making
have a
sure to
order.
file the motion
It's
so that
necessary before trial.
they're just not
But
sharing it back
review
and
the
forth.
materials that are relevant, and I agree.
I think
The
that's
phone should be limited
appropriate.
To D, E, and F, not the entire phone. And those materials would be
Yeah.
provided to Judge Kearney in a motion in limine regarding conscience of guilt. Also, will dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense.
True.
It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
I don't know what just buffered. Where did that go? Oh, that was the feed. All right.
Of guilt.
Thank you, counsel.
Thank you very much, Your Honor.
Okay.
Good morning, Your Honor, counsel.
Morning.
Judge, this is a Lampron request, is the familiar with it, Your Honor.
We've heard about Lampron. It is the case that they cite in governing the Rule 17 requests. We're going to continue on, but we've seen these arguments made by Karen Reed's defense team in trying to get information from the Sandra Birchmore investigation and case. So we have seen these requests in other cases saying, look, this information in that other case might be relevant to my case. Give it to me.
purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out.
Well, I mean, it's not really the
happened to look at
11th
the
hour
Reed
for
docket
you
last night.
because this is your case is separate. This isn't really the 11th hour for you. Brennan is saying, what you have, can you give it to me? Or a narrower version, can you give it to me? It doesn't really delay your case at all if the work's already done.
It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning there has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, judges, that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that.
But that's not really relevant for whether it gets turned over or not.
You can have for a prosecutor.
What's the privacy interest?
Sitting in the judge's lobby,
because this goes
shooting
to
the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not
Lucas like, I didn't do it. The judge.
And then
I
they
didn't
had
do
the
it.
lowest hanging fruit
I didn't do it.
you can get as
Not
a
it.
prosecutor, going to a grand jury without
But that's
anybody
not
else
the
there.
that's not the question
Crafting the
though. I get
evidence
it.
in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution. As
Your
an
Honor, as a
attorney,
law nerd,
saw
I have
this-
thoughts.
I read the search warrant, out of the Herald or something. And I was
The search
prompted to
warrant's in
write
the
this
Herald?
press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page
But the arguments. Oh shit. I paused at a weird time. The argument is not whether or not they should have been granted a search warrant. They should search the phones. They shouldn't search the phones. That's not the argument. The argument is, should that shit be turned over to Brennan? That's it. Does Brennan get access to the shit he's asking for? That's it.
about
I told you the feed was choppy this morning.
in there, right?
It was in its feelings.
Find and isolate communications.
Feeds in retrograde. The feeds.
Criminalize communications.
The feed granted its own code red motion.
And if you look at read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs, to fight any way she wants, and
She can fight it.
talk
That's right.
to anyone she wants, and communicate with anyone she wants, and say, hey, don't share this. It's between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs.
But that's not
when
where
the
we're at
government
in the proceedings.
cites that just as a bare proposition. She tried to keep this secret. She communicated with Aidan Kearney. Then we're going to make this gargantuan leap that she
can do
sharing
those
the intent
things.
to intimidate witnesses. So the whole thing is completely bereft of any evidentiary.
Counsel, I appreciate where he's at, but the question is not whether Karen Reed had like the criminal intent to intimidate witnesses. It is whether or not her actions or conversations but go to consciousness of guilt. So we're not even there yet because we have to see if it gets turned over.
Value, Your Honor. just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to
You're not
get
arguing
an
the search
indictment
warrant.
and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter,
That's
I
a fair
looked
argument.
at
It's not
the-
relevant.
the
It can't
docket. I
go
spoke
into
with counsel,
evidence, so it can't get turned
from the
over.
Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue
love my
about
standing desk.
communicating with Mr. Kearney and consciousness of guilt, unless it was quote unquote,
I cannot sit
the
for
door was
7
open,
hours.
which of course is sort of a proposition that is, out
I'm
in
not
the
happy
ether,
when I
and
sit
that
for
ain't,
7
that ain't ever gonna happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California, we talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge,
And that's a fair
here,
argument. If it's not relevant,
They
why
just
turn it over?
want to get in
They
Mr.
can't get in.
Kearney's phones. We're not concerned
can't just go
about
snooping.
what's in Mr. Kearney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications.
Right, they
in their
can't just
client's
go
phone- in my client's phones, Your Honor. So
peeking.
there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness
That's in this
intimidation
case.
allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right when to say that, oh, these first two phones.
Counsel, you are telling me that Brennan is not stating it accurately? Counsel, what? Your Honor, he's confused. Your Honor.
We already got into them. So the taint team covers everything, all of Mr. Kearney's phones.
Right.
So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss
Sure.
in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, while maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment.
Yeah, obnoxious isn't the standard.
So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Kearney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that they communicated. The fact that they communicated cannot be a basis for a criminal investigation in the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context.
We love context.
This is from Commonwealth versus Onyx White. That is a landmark case that involves the notion,
But is
and
it
the government
Hornbook?
is always pushing the
Alessi
envelope,
would
Your
like to
Honor.
know. I'm just
That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion.
yeah.
of
You don't just
government
get
power
everybody's
to search
phones
people's
because
private information.
you feel like it.
Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. just two quick quotes.
By the way, coming up with a nexus between a phone and a crime is generally not difficult. Like this is not a hard standard. It is the most minimal. It is not even a pothole. It is not a roadblock. It is barely a speed bump. It is not hard because they had to travel to the scene of the crime. Their phone would tell us if they're there at that time. It's a very low standard, but you can't just be like, well, people have phones and crime happens, so give me the phone.
Your Honor.
It's still not a difficult
The cell
standard.
phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes,
But I think this
thoughts,
argument goes more towards
communications,
they shouldn't have his
photos,
phones at all and not
loved ones, information
to
involving
Brennan
loved ones.
shouldn't get it. I think it's they
court should
shouldn't have it at
not
all
view
and therefore
lightly
Brennan shouldn't get it.
what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So the
I
cell
appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in
I like this judge.
88 Special
This judge is like the shit's out of the horse, counsel. Now what?
88 Cosgrove's possession.
Mudrucker,
custody,
thank you. This
control.
is the judge. This is
It's
this
already been
judge.
seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that
Sisitsky?
does not contain the long list of materials that you just
Also, Your Honor, I'm sorry. The law nerds seem to have a strong judicial preference in this case. I'm not going to say that beards are persuasive. Sometimes they are. We also very much stand Judge A. But some of our favorites are gloriously bearded. We are what we are. The law nerds would like to know if you're busy in April and May and June. We have questions. You know,
rattled off.
what's
from
your
the
docket
Oxford
look
case.
like?
Well, Judge, it never should have happened. The search never
But
should have
that
happened.
issue
It should have
isn't
gone through
before
the
me,
taint.
counsel. That issue isn't before me. The issue before me is
He did let
what
him
he's looking
talk
for
and make a
relevant.
record before
Right.
redirecting.
What do they have? What do they have?
He gave him
to
some
set
time.
that up? They have the fact that they spoke, and the fact that they spoke is not evidentiary. It's not relevant. If the
That's the
fact that they
question.
spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done.
We do stand competency
we're-
up in here.
The court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privilege
Cosgrove
information
is the
in
special
phone is
prosecutor in that
ridiculous.
case.
There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife
Counsel,
communications.
you're not asking.
No, not you, just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications, we're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint
protections.
team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampert, it talks all about undue delay. They had this back in
But if
February
it's
of
already
24, and here we
extracted-
are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no.
I see confusion in the chat. I'm gonna try to head off the confusion in the chat. The defense attorney was talking about a husband and wife privilege. He was talking about essentially a reporter privilege. And he was talking about attorney-client privilege information that are all in Turtle Boy's phones, and that he is making motions to keep out that information because the taint team should remove those communications, and those communications should not be given over to the Commonwealth in Turtle Boy's case. And the court said, I'm not here to decide that today. He goes, I know, but I want you to know what the problems are before we start just willy-nilly turning over stuff that was extracted out of a phone, because it gets extracted, then it needs to go to the taint team. Then there are privileged communications in reporter privilege, spousal privilege, attorney-client privilege. Those privileged communications need to come out before anything can get turned over to the Commonwealth in that case or the Commonwealth in Karen Reed's case. So that's where they were going. And the court's like, that's not my circus. That's a different circus.
If they have to say, we will find something criminal in those phones. Thank you, Your Honor.
So that was what he was talking about.
ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for
Y'all can
the
giggle at the word
defendant in
taint.
this
It's a
case.
funny word every single time.
It's going to be Attorney Elizabeth Little, Your Honor.
So Attorney Little, the court's allowing Attorney Little to be heard.
First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look,
Oh, Bradle, not Cosgrove.
Attorney Bradle, apologies, Your Honor. There are.
I think someone said there's a lot of attorneys around. Miss Little, we 100% forgive you because you did not mispronounce a name. There's a lot of attorneys, but at least you're not calling Mr. Alessi Mr. Alessi. We get it. It happens. She's like, okay.
Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. And so just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
She said she'd be quick. She's
ADA
quick.
Brennan, I'll hear from you in response briefly.
Very quick. I like Attorney Little a lot. She's incredibly easy to follow.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments.
I think they were talking about your
It is
facial
true there was a
showing.
no bill, and it is true that there is litigation in Mr. Kearney's case. But these phones are in the possession
But
of the district
facial
attorney's office.
facial
Information
showing.
is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional
And
prowess
and
of
then
Bradle. It is this reflective of consciousness of guilt. And
Attorney Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion
that's a separate issue. Whether he gets it is the first issue, whether it's admissible is the second issue. And that's not the issue they're there for today. Whether he gets it is the issue.
there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses
We're aware.
then offered to the jury that they were being harassed by social media bloggers suggesting at the behest of Ms. Reed. That is an entirely separate issue than conscience of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed.
Well, that's helpful.
I agreed to that.
I mean, that's
because
the
I will
law.
instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a conscience of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The conscience of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information, to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows that as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so
I'm gonna have to go back and
should
rewatch
be
that.
available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Kearney if appropriate, and then she should decide the admissibility in the Commonwealth versus Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been warned. Guess.
Well, the feed definitely jumped into a different subject matter immediately. But as many of you have let me know, and as we are coming up of a very, very rapid hard stop, the court said, I will get you an answer as quickly as possible. And by as quickly as possible, the court meant today. So let's go to the court's ruling real fast. We are not going to have time to deep dive into it. We are going to have to overview it, but we're going to do it anyway. So let's go. Because y'all want to know. I want to know. Y'all want to know. We want to know. The court ruled. Let's go. Let's go. Let's jump into the court's ruling real quick. We're not going to go through the legal precedent. We're just going to hit the high points. So swoop, swoop. Let's go, everybody. 7 hours in. It's been a long court day. All right. This is under the Karen Reed case number, memorandum of decision and order on the Commonwealth's motion for records from the other docket numbers and from the special assistant ADA in the Turtle Boy cases. We know what the defendant is charged with. This matter is before the court on the Commonwealth's motion under Rule 17 and Lampron, requesting that the court order production of certain cell phone records in the custody, possession, and control of the DA's office, Special DA Cosgrove, that were obtained by search warrants in connection with 2 criminal cases currently pending against Aidan Kearney. Kearney. I have a hard time pronouncing the K differently. I struggle. Either way, we'll go with Turtle Boy most of the time. But after a hearing before the court on March 20th, earlier today, at which time the court heard arguments from counsel for the Commonwealth, counsel for Mr. Kearney, as well as counsel for the defendant, and for the reasons stated herein, the Commonwealth's motion is allowed in part. I guess we'll see what's allowed. Allowed in part. So we'll go through those parts real quick. The Commonwealth seeks data from 2 cell phones belonging to Turtle Boy that were seized and searched pursuant to search warrants issued in the 2 criminal cases. In those cases, among several other charges, Mr. Kearney has been charged with multiple counts of intimidation of a witness. The witnesses in question are individuals who are either witnesses or related to witnesses in the Karen Reed case. The Commonwealth argues that certain data seized from those phones from April 1st, 2023 through October 5th, 2023 is relevant and has evidentiary value to the current case because Defendant Reed had ongoing communications with Mr. Kearney during that time period and shared with Mr. Kearney defense theories, materials, and other evidence from her case, sometimes through secure messaging apps and through an intermediary, which she does talk about in the Discovery ID docuseries. And such communications include witness information, home addresses, grand jury minutes, autopsy photos, and the like. Some of those things are sealed if that is true. But that is the argument of the Commonwealth. The court is not finding, the court is stating the parties' arguments. An inference can be made that the parties encouraged Mr. Kearney to personally attack witnesses and their family members with the sole purpose to embarrass, intimidate, harass, or deter those individuals from testifying. The Commonwealth intends to use this data concerning certain communications found on Mr. Kearney's phones related to such alleged witness intimidation in light of the defendant's ongoing communications with Mr. Kearney as evidence of the defendant's consciousness of guilt. The Commonwealth argues that those materials are not otherwise available. I agree with that. And it cannot properly prepare for trial without the production of such materials. They're going to go through the case law on this. We are not going to go through the case law on this. Let's see. At the hearing, the Commonwealth requested data from 2 phones, including communication between Aidan Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to, and then they list all of them. You heard them in court just a few minutes ago. Photos or videos depicting evidence of intimidation of a witness or any witness or family members, which we heard them describe in court. Data evidencing dissemination of data depicting evidence of intimidation of a witness, as Brennan described in court. Let's see. With regard to the Lampron requirements, no, the court finds that the request has been made in good faith and that the failure to obtain materials may tend to unreasonably delay the trial. Accordingly, the motions allowed in part such that the court orders the DA's office to produce from the 2 previously identified cell phones that were obtained through search warrant, quote, any and all evidence of communications between defendant and Mr. Kearney concerning any witness or family members of witnesses. So this is what's being turned over, these 3 things. So these 3 things are what is being turned over to ADA Brennan. Any and all evidence of communications between Karen Reed and Turtle Boy concerning communication between Mr. Kearney and any witness or family members of a witness involved in the murder of John O'Keefe, to include but not limited to the names we went over before. Pictures or videos depicting evidence of intimidation of witnesses or family members of witnesses, including but not limited to the names that they went over in court. Data evidencing the dissemination of data depicting evidence of intimidation. So I think anything that was posted on the internet, social media, text messages, whatever, anything that shows that this was shared, including the same witnesses listed. So the court has allowed these specific areas of information to be turned over to Attorney Brennan. What does that mean? That means he will have access to this information, period. If Attorney Brennan wants to bring in any of the information from cell phones that he receives, there still have to be motions made to bring that in. So we may see motions in limine regarding that. We may not. So it doesn't mean that it is admissible. It doesn't mean that it is relevant. It doesn't mean that it comes in as consciousness of guilt. It means that the Commonwealth has access to it to review it, to make motions that it may or may not then come in at trial. So that's it. I think we will see motions coming in regarding that, but the Commonwealth is going to have to review it first, and then we will see. So again, we will see. The Commonwealth has put Aidan Kearney on their witness list. I think they are probably going to, well, they've asked that all the witnesses are subject to a sequestration order. So this will be part of whether or not Turtle Boy will testify in this case, be called to testify in this case, and to turn it over. Singing Fan says, and the defense gets it right. The defense should get it in reciprocal discovery 100%. But could the defense already have it? If this is limited to communications between Karen Reed and Turtle Boy, then the defense should have the Karen Reed side of all this information. So the Karen Reed side of this, these are communications between Karen Reed and Turtle Boy. The defense should have the Karen Reed side of those communications. So this does not mean that it is admissible. This does not mean that it is coming into trial. This means that the prosecution will have it. So yes, they have to turn it over in discovery, but also the defense probably has it. So with all of that, I have literally 3 minutes. I'm going to answer just a few questions. I think I did just answer a few questions. It's been a very long court day. Tiny Dragon said, don't they already have Karen's phone? They don't have, the Commonwealth does not have Karen Reed's new phone. They have her phones that were taken at the time of her indictments in 2022. This time period, this is a great question, Tiny Dragon. This time period covers, and I'm going to scroll back up. This time period covers 2023. So they do not, the Commonwealth does not have Karen Reed's phone records from, well, they might have her records from the carrier. They do not have a data dump from her phone from April 1st, 2023 to October 5th, 2023. They took her phone. I think they took the last phone from her in June of 2022. So this is new information. Gray Space says her phone got taken again in January 2024. I would need to go back and look. That may be true. I don't know. So if they did take another phone in January 2024, then they have her phone. That doesn't necessarily mean that they have everything that might be in his phone. So this is a step between whether or not this will come in to be used as consciousness of guilt. We will talk about consciousness of guilt down the road. For those of you saying they grabbed her phone in January 2024, I don't know when they went to grand jury on the witness intimidation stuff, but it would make sense to me if they were investigating that after the fact, that would be closer in time. So that makes sense to me that they would grab it, because they tried to indict her later on witness intimidation and no billed it. So that might have been part of search warrants in that investigation. Either way, we will see where this goes, but there's going to be more motions. This case is going to be hot and bothered until it starts jury selection. And even then there will probably be hearings interspersed with jury selection. Jury selection will not be streamed. Hearings will be. It looks like there's a hearing next Tuesday. It's probably going to be while I'm on a plane. If that's true, I will cover it either after the fact or the next day. Don't worry, we'll cover it, but not in real time. So I'm going to answer like 3 things. Y'all, law nerds, have hung in there. Today was a long and busy court day. And if you're like, how did the attorneys jump through so many topics? It was a lot of topics today. That's what pretrial motion days are like. They are very long, busy days. They are very long, busy days. Thank you all for the mod love. To everyone who gifted memberships, welcome new members, and thank you. And thank you. I appreciate it. So Pro Gamer says that Hank Brennan keeps changing the reason he wants Turtle Boy's phone. Witness harassment has become consciousness of guilt that he hopes to file. He wants to use evidence of witness harassment as evidence of consciousness of guilt. And he said he hopes to file it, not to try to extrapolate Brennan's behavior, but the reason he's saying he hopes to file it is because he doesn't have the information yet. So it's too speculative. If he goes through the phones and there's nothing there, he can't file a motion and say, I want to introduce this evidence. So he has to go through them first. We'll see if he files it or not. I'm sure he will find something that he wants to file. I'm sure that he will. I'm sure that he will, right? So, Emily, I have seen a lot of questions in the chat about whether or not Brennan added Yannetti, Little, and Jackson to his witness list. It's not going to fly. How is that possible? It's not going to fly. He's not going to be able to call them. They can't be excluded from trial. So it will be subject to motions if the Commonwealth tried to call one of the defense attorneys. The issue is that the defense attorneys have given interviews and have been present at interviews that might be used. So they are witnesses to statements made to reporters and what have you. It would be a shit show if the Commonwealth tried to call the defense attorneys, but it would be related to interviews. So can they add them to the witness list? Sure. Is something going to happen? We'll see. You guys are saying that Boston 25 is reporting it. I haven't seen the updated witness list. We'll take a look. The defense will make motions and be like, Your Honor, WTF. So can attorneys file things in court? Yes. Does that mean it's going to happen? No. Edward Kirkpatrick said, rewatch and notice the death glare of Yannetti. Oh, Yannetti looked feisty. Dubra said, Brennan doing Brennan things 100%. And asked, do we know if the board is looking into Tully or Buchanan? Trooper B. We know that different troopers had disciplinary action already happen. I covered it. I do not have it off the top of my head, and I don't want to misstate it. There were losses of vacation days and stuff like that. The only discipline that I think was still pending, from the best of my memory after a 7-hour day, is the stuff with Proctor. I think everything else that was done has already been done, but others were disciplined. It was minimum. It was a loss of a few vacation days and things like that. But it was not nearly as significant as what we saw with Proctor. Nobody else was fired. So it is not at the top of my mind, but chat probably knows. So I'm not surprised, and it'll come up. What about Higgins? I don't know anything about Higgins. RS asked if I'm going to be covering Eminem. We need a whole music court case. It's on my docket. It's on my docket for sure. Law Nerds, I've got to bounce to a meeting. I appreciate all of you. It's been great spending a court day with you. We're going to have lots and lots of court days coming this year. It's part of why I got a stand desk. A number of you asked what stand desk I got. I got the up desk. There are plenty of stand desks out there, but this one fit my space and my needs. But I love having a stand desk because these are going to be long court days, and I did not want to sit and stream for 6 hours a day for 6-7 weeks. And then when we get into Kohberger is going to run from the end of August to November. So I'm going to need the ability to stand and wiggle and move around, or my back is going to be mad. I don't know what's up with you. What's up, dog? I don't know. What's up with you? That's annoying goose. That's hilarious. So, Law Nerds, you are the best. Get the Law Nerd app. I'm going to put up a community post later today for you guys to share your friend codes in Midas Merge if you are so inclined to friend other Law Nerds in Midas Merge. For all of you that found this game today, I'm sorry and you're welcome. You're going to love it. And we love some casual mobile gaming while we are busy watching court. Yes, we do. All right, y'all. Do it. Get your stand desk, get your games, download the Law Nerd app. Do it. I will see you guys next week. I will see you on Monday for Quick Bits, Law Nerds. I will be recording Quick Bits with you. I will keep you posted when, because it is not prepped yet, and it's going to depend on my day tomorrow and my kids' competition schedule. So with all of that, bye for now. I'll see you in court soon. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.